Notice has been issued to
Beg
the
pardon, my lord. Item 11 by the list, my lord.
Yes.
I am suffering a fever, my lord.
Let's see. When it's called out, you have
My-
come all the way here, sir.
My lord.
My lord, 1 and 2.
Yes.
State is the appellant. Your lordship has admitted the appellant. Notice has been issued. I
When
think no, the notice has not been served or respondent has not appeared. A demand notice under the Registration Act for impounding of the sale deed has been quashed by the Honorable Single Judge on the ground that the sale deed is declared to be invalid in a subsequent stage. Our case in short is that validation or invalidation of this has no concern with the chargeability of the stamp duty and
neither AD card nor undelivered notice has been returned from the sole respondent. Fresh notice returnable. 4th April. Same. 2 matters.
Item number 2.
2 is the same.
No.
Item 2 is
Item 2 is different.
WA 330 of 2000.
I am sorry. Yes, my lord.
None appears.
No, my lord. Yes. I am the respondent.
Yes.
My lord, may I submit one thing? The PCCF, Mr. Nair is in Similipar. So-
He can appear from there. From wherever he is, he'll appear.
No, he will appear from there.
Ah.
He is also sending the second officer to physically appear
We
tomorrow.
are not insisting on physical appearance. Let's be very clear.
Yes.
He has to appear. In this court, sir, you can take it. We don't insist on
No,
physical
he will
appearance.
appear. He will appear.
Virtual also, they can appear.
Yes.
Wiki list item number 3.
In 3, I am appearing on behalf of the respondent. In pursuant to the notice from this honorable court in condonation of delay, I appeared on 9th December and filed my vocal on 9th December along with the objection to the miscase for condonation delay. My name has not been reflected in the cause list.
And here, sir, first let us hear the appellant.
The state has filed this appeal challenging the order passed by the Honorable Single Judge, whereby the Honorable Single Judge passed an order directing to count the date of upon engagement and which was been subsequently quashed by the coordinate bench of this Honorable Court with regard to that engagement of Shiksha Sahak pursuant to a particular letter. And this Honorable Court quashed the entire selection process which were done pursuant to that letter, and subsequently given a direction that they may be allowed to participate in the subsequent recruitment process. And accordingly, the present respondent appeared in the subsequent recruitment process and got engaged. So from that date, their service is counted, but the Honorable Single Judge has passed the order to count the service from that date, initial date.
What do you say?
My lord, in this case, notice has been issued in condonation delay only. I received the notice on condonation delay to appear 9th December.
All right. You want to file a reply.
I have already filed reply along with my vocal number on 9th December.
All right, sir. Where's your reply? You have to trace it out and place it on our records. Counsel appearing for the respondent states that he has filed a reply which is not on record. He will ensure that it comes on record. You have got a copy of the reply?
No, madam.
Copy of the reply be served on
I have already
counsel for the
Lord, I will read.
for the appellates. All right. List on 5th April.
5th January.
Item number 4.
So give the date properly.
5th April, sir. 5th April. Item number 4.
May I please? My lord, item 4, Mr. P.K. Mohan, the senior counsel, is on accommodation.
There's no accommodation. All tell us what it is. Acha, this is Mr. P.K. Mohan.
Yes.
All right. Counsel for the appellant is stated to be senior counsel for the appellant is stated to be in some personal difficulty. All right. Yes, sir. 11th April. All right.
Item number 5.
Item number 5 minutes on behalf of the GN Shaw minors, praying for announcement for next week minors. He is an out of station minors. Any day of the next.
When a matter is listed in the High Court, how can people go out of station?
Any day of the next.
What is the matter here?
My record shows for the first time it is listed after 5 years.
Single judge be quashed and set aside. What does single judge say?
The regulation 2 matter.
Counsel, the appellant stated been some personal difficulty. 18th April.
Item number 6.
This is the appeal preferred challenging the order dated 8/8/2017. So passed in double petition number 9197 of 2013. By virtue of the advertisement under Annexure 2, my lord, having requested qualification, the appellant applied for the post of part-time art education instructor, having the qualification of PG in music, but in the draft selection list, her name appeared. And after verification of the documents, the final merit list was prepared. And in that, her the candidates of the appellant was rejected as there is no requisite qualification the appellant is having. My lord, the requisite qualification in the as per the advertisement is degree and PG, but answer to my lord, PG qualification is the required qualification. She has applied that for that post with that qualification, but she could not be selected. After clarification of the government, the corrigendum, and in that corrigendum, the focus on 2 institutes, namely namely the that is under Annexure 6, my lord, at the running page at 53. The 2 that means 2 institutions, the appellant from where she could obtain the degree, but she has finally obtained the PG degree, that Master in Music, from the institute, that is Indira Kala.
So you're not ready with the matter.
My lord,
You're not ready with the matter. You're hunting high and low for pages. You're panting, puffing. You came running or what?
I'm sorry, my lord.
No. You came hurriedly up the stairs or something.
No. She has obtained.
You want us to pass it over. You want us to gather your thoughts because you're all over the place. It's taking you time to even hunt the correct pages.
My lord,
We'll pass it over. Get ready properly. Just marshal your thoughts correctly. And then normally, sir, a good hint. I'm sorry to be advising. You're a very senior member, I think, no? You've got several years of practice.
Yes.
Don't take it amiss that we're trying to give advice or anything. When I was a lawyer, I would prepare a neat list of dates for myself. And I would write on that list of dates what page I have to refer to. It's a very easy way of doing things. When you present it before a court, it becomes easy. Otherwise, as court, you don't know which page the judge should read. If you're yourself not at that page, it will be difficult. No? So we'll pass it over. Just gather your thoughts and then make a presentation. All right, pass on.
Item number
I
7,
request my learned friend to serve a copy of the, in the meantime, I will also go.
Sir, he's asked something. Have you heard him?
I have given copy. I have received that the copy of this, sir.
Sir, is he lying? He can't be lying to you, na? If he doesn't have a copy, just give him one more copy, sir.
I will just.
I please your lordship. Here is a matter that time in 2017 that CESU has in power. Now force in Tata Power has come to this power. I am sure that you lordship permit to file a affidavit or not. That appellant is CESU in 2017. Now to 19 that has changed to Tata Power.
Counsel, the appellant wants to file an application to bring the correct name of the appellant on record. List on 25th.
item number 8,
Item number 8, my lord. Item number 8, the council became experiment. So let the matter come 1 week after. I will take. I will assign to the matter, my lord.
You have been assigned the matter.
Not assigned, my officially not assigned. The office instructed me to mention as the beacon I was the expert, the matter will assign to me in future, 2 or 3 days.
Office means this appellant.
Appellant.
All right. Mr. Acharya states that he has now been instructed to appear on behalf of the appellant and seeks adjournment. List on 25th April.
1 week after.
25th April. Item number 9,
After vacation, man. After vacation.
25th April.
Item
25th April.
item number 9,
Item 9 matter, the overage relaxation matter, already decided this matter, my lord. Overage relaxation matter.
So what? Decided meaning what? In your favor, against you, what?
My lord, in writ appeal number 488 of 2017, by the order dated 18/10/2022, your lordship dismissed the writ petition, writ appeal filed by some other person. And here also, particular order
So
is
this,
challenging.
so this has to be dismissed.
Yes, ma'am.
That's what I'm asking. So where is that order? Where is that order?
Sorry, I could not.
You also do not have. Very good, sir. Excellent. What is the date of the order?
18/10/2022, writ appeal number 488 of 2017.
All right. By virtue of the order dated 18/10/2022, in writ appeal 488 of 2017, the present writ appeal is also dismissed. All right.
weekly list item number 10,
10 I am lordship in BC lordship. Permit to withdraw lordship.
Appeal dismisses withdraw.
item number 11,
I not feel well. I prayed a short adjournment. It will come Thursday, my lord. Thursday, coming Thursday.
Counsel, the appellant states that he is not well. So what is the limitation steps you've not taken for 5 years now? What's the delay? There's already a delay of 342 days in filing this appeal. Despite the steps having defect having been pointed out way back. No, despite the appeal having filed 5 years ago, no steps have been taken for even filing an application for condonation of delay. The court does not consider it appropriate to grant any further indulgence in the matter. The delay is extraordinary and unexplained. Accordingly, the writ appeal is dismissed.
item number 12,
Yes.
Collector come the district project coordinator MGA NREGA Burgard is the appellant in this writ appeal challenging the Honorable Single Judge judgment dated 21st March 2018. May be permitted to place the, my lord, the fact is that the respondent, the Gram Rozgar Sevak, was imprisoned for a month or more than a month, more than 8 days, for which he was issued notice and then terminated from service. Now, he challenged that termination order in this honorable court by appeal number writ petition number 25685 of 2017, and by 21st March 2018, the honorable.
So last time you took adjournment for
Yes, my lord.
instructions.
To instruction that what is my position, whether I will, and I have been told that the cases I am continuing, I can continue.
What?
Cases that I am holding for the collector come DPC, I can continue to till disposal, my lord.
No. What has happened to the respondent?
Respondent.
He was involved in a criminal case. What is the outcome of that criminal case? That is what we take action on.
No, my lord, that I don't know.
So please read. This is your brief only, no?
Yes, my lord.
Please come to page, that last paragraph of the impugned order.
Yes, my lord.
Have you read it?
Yes. This court, therefore, interfering in the termination order, sets aside the same, but at the same time, taking into consideration that the petitioner is involved in a criminal case involving the charges under section 420-506 IPC, and considering the petitioner is already on bail, it will be open to the employer to take up the issue dependent on the ultimate outcome involving the criminal proceeding at appropriate stage, and in the event the petitioner is convicted, petitioner be treated to be continuing without any interruption and with all financial benefits.
What is the status of this criminal case?
That case is pending, your lordship. I am for the respondent number 1, your lordship.
You are continuing in service?
No, my lord. They have not treated me. After this order, your lordship.
Lordship, may kindly.
You have filed a contempt.
I have filed a contempt because the writ appeal was pending. Therefore, my contempt was dropped by this honorable court.
Dropped?
Yes, your lordship.
Mere pendency of appeal.
My lord,
I may be
contempt number, your lordship, 1579 of 2018, your lordship.
I may be pardoned, my lord. I have filed a miscase, my lord. In that I have given how he has misappropriated funds of the government.
That misappropriation fund not related to the impugned order,
yes,
your lordship.
That is not related.
Order, lordship. Admitted, your lordship, one private person. My lord, I was appointed in the year 2007, your lordship. After 11 years of my service, your lordship, in the year 2016, one private person lodged an affair against me with allegation that he had given some amount to me, and while asked to me to return that money, I did not return. Therefore, he filed lodged an affair against me. In that case, I was arrested and inside the custody more than 48 hours, your lordship. That complaint case, that criminal case, not related to my job, your lordship.
And in the miscase, para 3
guideline of the MGNRGS, my lord, those guidelines submitted, filed by my learned friend in counter, the learned single judge has allowed to re-engage me, reinstate me, your lordship.
My lord, in the meantime, during pendency of the writ petition, he has committed a serious misconduct, like embezzlement of funds meant for beneficiaries of Manrega by showing his wife and other family members to have worked and taking payment on that account. That is there, my lord, in the annexure of the writ petitions I have filed, that they have.
You filed a writ petition?
My lord?
You filed writ petition?
No, my lord, in this petition, my lord.
This is petition or what is this? This is a petition?
Yes, my lord.
I thought it is a writ appeal.
No, my lord. In this writ appeal, I have filed a petition to apprise the honorable court about the.
No, is it connected to the case or is it subsequent cause of action?
So that was during the pendency of the writ petition.
So it is a subsequent cause of action.
Yes, ma'am.
How can we decide it on that? For that subsequent cause of action, you have to take separate action, sir.
Yes, and we have not, that's why we have not engaged him further. Because of
Have you
this,
issued a notice?
yes, he has been issued a notice.
Where is that?
Embezzlement and other.
Where is
things.
that?
That is because the subsequent cause of action have not filed that.
My lord, they have not received issued any notice, your lordship. Simply file that document with the miscase, your lordship, in order to get the stay order on the impugn order, your lordship. "11 years of service, your lordship, there is not a single allegation against me, my lord. And I was terminated based on a private person, not related to my job, your lordship. Then I have taken 50,000 hand loan, and I did not return to the informant. Therefore, he lodged an FIR, and I was in custody, your lordship. And the criminal case is still pending, your lordship.
Learned single judge has a report to section 25 of NREGS Act, my lord, and section 25 doesn't say that it is a service condition or.
Where is section 25?
Yes, my lord. Maybe this book.
No, ask him to wait. Ask him to wait. Take out the barrack.
National Rural Employment Guarantee.
Yes, sir.
Yes, my lord. Page 15, let's have got it. Penalty for non-compliance. That is chapter 6, my lord. Miscellaneous. Whoever contravenes the provisions of this act shall on conviction be liable to a fine which may extend to 1,000 rupees.
How is this relevant?
Then that explanation, lordship. The clause relates to penalty for
This notes on clauses, sir. This is not explanation.
Yes,
this is not an explanation. It's a notes on clauses.
Yes, my lord.
What is your proposition? How is this relevant?
Because this section on which the honorable single judge has based his.
No, he's not based it on this.
Yes.
Who said he's not? He's not based it on this.
I'm placing that for your lordships.
In fact, he says this is not relevant.
From the discussion in the disengagement.
There is absolutely no involvement of the above nature of offense. You are completely misreading the judgment itself. The judge has said exactly the opposite. He has said there is no involvement of any such offense. How are you even reading this?
My lord, the engagement is a
All right. The present appeal is directed against
this
an
is
order
a
dated
contract.
21st March 2018, passed by the learned single judge, allowing writ petition civil 25685/2017, filed with the respondent. Full stop. Paragraph in the said writ petition. The respondent had challenged an order passed by the present appellant, disengaging him as Gram Rozgar Sevak in Pikemal block without complying with the principles of natural justice. Paragraph. A perusal of the said order dated 17 January 2017 issued by the present appellant reveals that the disengagement was only on account of the respondent having been remanded to judicial custody in GR case number 703/16 under sections 420/506 IPC on 3rd October 2016, and then having been released by the SDJM Padampur on 11th November 2016. Full stop. It was concluded that since he had been imprisoned for more than 48 hours, the respondent had committed breach of trust and therefore was being engaged, open quotation, on the ground of misconduct, unquote, with effect from the date of his arrest, that is 3rd October 2016. Paragraph. In seeking to defend the above order for the learned single judge, it was contended by the present appellant that a circular dated 21st May 2012 issued by the appellant permitted the disengagement of contractual employee on the ground of, open quotation, misconduct / inefficiency, unquote, even without a hearing. Stop. Paragraph. The learned single judge held, and in the view of this court rightly, that the said circular had no application to the case on hand, since the respondent was taken into custody on the basis of a private complaint by a private individual, and the case in which he was imprisoned had nothing to do with his employment whatsoever. Full stop. Learned counsel, the appellant is unable to explain to this court why the learned single judge was wrong in coming to the above conclusion. Paragraph. Before the learned single judge, reliance was sought to be placed on another letter dated 5/12/2012, in terms of which a non-performing Gram Rozgar Sevak could be disengaged under Section 25 of the MGNREGS Act 2005. Stop. That provision contemplates contravention of a provision of that act in order to attract penalty. Full stop. As rightly pointed out by the learned single judge, there is no charge against the respondent that he violated any 25 of the MGNREGS Act, and therefore that provision also had no application to the facts on hand. The learned single judge has already observed that it will always be open to the appellant to take appropriate action depending on the outcome of the criminal case. Full stop. The court is informed that the criminal case is still pending. Paragraph. The counsel for the appellant then referred to IA number 290 of 2018, filed in the present appeal, in which a copy of a letter dated 5th April 2018, issued by the Additional Project Director (Administration) DRDA Bargad to the BDO Pikemal block has been enclosed. Full stop. That letter requires the BDO to hold an inquiry into the issue of a job card to the to the respondent. Full stop. In any event, the said letter appears to be an independent and separate cause of action, unrelated to the disengagement order which was challenged before the learned single judge. Full stop. Consequently, the appellant cannot possibly rely on a subsequent development to justify the disengagement order. Full stop. For all of the aforementioned reasons, the court finds no reason to interfere with the impugned order of the single judge. The writ appeal is dismissed.
Item number 13.
May it please the court. Your Lordship, item 13, we are led by Mr. Parija, learned senior counsel, who is currently indisposed this week. Your Lordship may kindly have it on some other week.
Well, I have filed a miscase here, and the matter is pending. I'm appointed in 2011. In 2022 also, I'm getting the same scale, basic pay, my lord. So I have filed a miscase, my lord. Minimum as due and admissible may be granted to me as revised scale pay. As due and admissible, I do not.
What is your miscase number, sir?
My miscase number is, my lord, 1584.
Is it there?
2022.
It's not shown in the list.
Revised scale as due and admissible, my lord. For last 11 years, I'm getting the same scale, 1500 some odd, as an assistant professor. Insofar single judge judgment is concerned, my lord, single judge allowed equal pay, grade pay, and the DA, but disallowed the house rent, which I have challenged in the writ appeal, and they say they will not allow the DA, differential DA. That is their challenge in the writ appeal. So basic pay, grade pay, my lord, I am entitled and DA as revised for assistant professor, and that may be given to me as due and admission. Interim application is 1584 of 2022.
All right, put down that application 1584 of 2022 notice. You appear for whom, sir?
Respondent number 2, Ravenshaw University.
Appearing for Ravenshaw University accepts notice. Reply to the application be filed within 4 weeks. Rejoined up for the next day. In the main writ appeal, you say counsel appearing for respondent number 2 university states that Mr. Parija, the senior counsel appearing on for the respondent number 2 is unwell today. List on 25th April.
Much obliged, Your Lordship.
In this case, I am appearing for UGC. My array opposite respondent number 4, and in connected says respondent number 3. My lord, there is issue. They are not solved the copy, my lord.
Mr. Mishra.
All right, my lord. I do not know. I will solve a copy. Let us fix a date, my lord. May I pray? So I'm not getting the salary because fix a date, my lord. Any date convenient.
25th April, it is possible.
Yes.
Item number 14.
Much obliged.
I am on VC, my lord. The sole respondent had died. I filed a petition for substitution. Notice has to go, my lord. Am I audible, my lord? Well, I am on VC, my lord.
So the man has died. Why do you now chasing the family for all this? You wanted to keep the order of promotion in abeyance. The man himself has died now. Why do you want to still chase his family?
VC, my lord. Am I audible, my lord?
Are we audible to you, sir? I asked you a question.
To this case of 2010.
I asked you a question. Am I audible to you?
Yes, my lord. Yes, my lord.
Please answer the question.
My lord. My lord said the party has died. Why I am making them?
I have asked you a question, sir. Have you listened to the question or you have not listened to the question?
I could not, I could not.
Because I'll repeat the question, sir. Learned single judge has asked you to consider his case for promotion, correct?
My lord.
The man has died now.
My lord.
Why do you want to chase his family now?
No, my lord directed that to give him a promotion from that.
The man himself is not there.
My lord.
What is the point in substituting his LRs? You're not going to give the LRs promotion?
No, my lord.
All right. The respondent has died during the pendency of the present petition,
My lord.
present appeal.
My lord.
Given the nature of relief granted by the learned single judge, the court sees no purpose in acceding to the request of counsel to the appellant for adjournment to bring his LRs. The writ appeal is disposed of.
My lord.
That's only a writ petition, I think. What is the writ petition for? You say the appellant has died, the petition has died, the petition is disposed of as having abated.
Item number 15.
I am for the opposite party number 1, my lord.
None appears for the appellant, dismissed.
Item number 16.
Sure, this is CMPL file. The petitioner, in fact, the client had taken away our Voklatnama long back, but due to his serious illness, he could not appoint a new advocate for pursuing this review petition. So that is why it was dismissed on 27th October. But again, he approached us thereafter, okay, you please take it up. So I have a very simple prayer, my lord, in this particular case. I have a very simple prayer. In fact, CMAPL is filed only for that. But the case is, in fact, the person concerned was, he was discharged from duty in 2009, but he was supposed to retire in 2012, March 31st. And they had, as per our instruction, he was allowed to retire. And one of the prayers of the writ petition was to reinstate, which has become infructuous. And we are not pursuing that also now. However, his retirement benefits and pensionary benefits, because he had put in more than 30 years of service from 78 till 2012, when his superannuation date fell. So our prayer, simple prayer is, let him represent to the government. And we understand that government is similarly placed persons, government is considering for their pensionary benefits. General Morir on the service with more than 30 years of experience, service in the department. So only that prayer, let him represent within a time frame and let the government consider in accordance with law.
That you should have done before the division bench should have withdrawn the writ, sir. It's too late now.
My lord,
this writ petition was dismissed in 2012.
My lord, if you lordship allows, just they have
1 minute. What is it? What is it you're showing?
This is, they have in January 20, last 20, they had issued a regularization of pension in favor of the petitioner, Krishna Mangaraj, ex-General Morir, Additional Sub-Collector, Office of Additional Sub-Collector, Puri. I am directed to send herewith the original grievance petition dated 6/1/20, 2000, received from Sri Krishna Mangaraj.
Then you withdraw all this, sir. You pursue that remedy then. You withdraw all this.
Your lordship can direct that let him represent on the basis of this and let government consider, that is all.
We are not directing. You withdraw, you say you will go, that is different. We are not directing anything. There is no ground for review.
He will represent only for his pensionary benefits.
Whatever, if you want to withdraw and do that, you please do it. We are not directing it.
Your lordship may, sir, you can order that way. Necessary direction may be issued. Okay. No problem, sir.
We are not issuing direction. We will be very clear. You say you will withdraw.
Agreed, sir.
What?
Withdrawal, as you say.
All right.
And to pursue his
counsel, the applicant seeks leave to withdraw the present application and states that notwithstanding the order in the writ petition and the review petition, the appellant will pursue the remedy of seeking pensionary benefits from the government by following up, by making a representation and following it up in accordance with law. Dismissed as disposed of is withdrawn with liberty spread.
Item number 17.
May I please, Your Lordship? Your Lordships, I appear on behalf of the petitioner in the matter. Your Lordship, we seek the liberty to file a few additional documents regarding the offences that are committed by the respondent's lordship along with judgments. It's my humble prayer before Your Lordship to please accommodate us with a short date and file the same, Your Lordships.
So we already adjourned it 3 months ago. You wanted to file some case law on maintainability. You can't go on adjourning it, sir. Sorry.
Lordships, we're in the process of procuring these documents. Your Lordships, these are like...
There's no document. You just have to get case law. This is not about document. You had sought adjournment to place on record case law.
I bow before Your Lordships, but if you could just
that's okay.
accommodate us. with a
We're very
short date.
appreciative you're bowing, sir, but 3 months are done.
Lordships, if you
There's
could
3 months is enough time to produce law.
We will file it as soon as possible, Your Lordships. If you could just accommodate us with the short date.
So we're not adjourning.
Your Lordships, I won't be able to assist Your Lordships in the matter.
All right. So we can also help you, sir. Counsel for the, you say this case was adjourned 3 months ago at the request of counsel to the petitioner who wanted to place case law to show how the writ petition is maintainable. Paragraph today, again, an adjournment is sought, which the court does not find to be. When asked to proceed with the matter, learned counsel to the petitioner expresses inability to do so. The writ petition is according.
Your Lordships, I'm a proxy counsel in the matter.
Very good. Very good. Sir. It's all right. Yes.
Press admission item number 18.
In this matter, we have got 5, 6, and 7, and 8. Let's see.
May I please, Your Lordship?
All right. Yes.
The petitioners or the villagers, those who have prayed before Your
18,
Lordship.
Your Lordship, definitely. My Lord, item 18, Your Lordship.
Yes, please.
18, my petition.
18 is...
Mr.
Biswal, sir.
Yeah.
I'm sorry, ma'am.
Yes.
Relating to giving the certificate by Denister 2 in respect of the high school that they are in possession of the land which belongs to the upper primary school. For that reason, they have given representation to the Tahsildar as well as the collector Moirvanj to demarcate the land and resolve the issue, my lord. Because the in the year 2002, the villagers allowed 2 rooms to high school to perform their classes there. Because they have not
as representation.
Annexure 5
September 2022 shall be considered by the collector. And after notice to the petitioner. And after our petitioners and after giving them a hearing, a reasoned order shall be passed not later than 10th April 2022 and be communicated to the petitioners within a week thereafter. The court clarifies it has not expressed any view on that.
With your Lordship's kind permission, may I be pardoned, my Lord? I have somehow assumed that mine is 18 instead of 15. My 15, my Lord, Your Lordship directed this is a matter relating to the insurance policy benefit. The wife, the husband has passed away. The father-in-law wanted to file an affidavit. They are possibly not able to file today. They wanted a prayer for adjournment. I missed it, my Lord. I am extremely sorry, my Lord. I may be pardoned.
All right. Item 15, you say Mr. Mishra wants, seeks and is granted 4 more weeks.
No, my Lord, here the other side has to file.
Sorry?
The respondent, the father-in-law has to file the affidavit, my Lord. The counsel informed me that they are not able to do it today because the father-in-law is not well.
Right. Mr. Mishra informs the court that counsel for the respondents 3 and had asked him to request for more time from this court to comply with the order dated 22nd November 2022. The time for compliance is extended by 4 weeks. Interim order to continue. The list on 25th April.
Right. I'm extremely sorry for the inconvenience. I apologize.
Item number 19.
Matter may kindly be listed before another bench, my lords.
All right. List before bench of which Justice Raman is not a member on 18th April.
Item number 20.
No instruction, my lord.
No instructions dismissed.
Item 21.
May I please, my lords? Petitioner, my lord, is a quarry owner, my lords, and he crushes these boulders into small sizes, my lord, and he has a fleet of transport vehicles. And the persons who buy these chips from him, they usually hire these trucks, my lord, for transportation, my lords. And he receives transportation charges along with the cost of the chips, my lord. A 43 proceeding, my lord, was initiated against the petitioner on the ground that certain materials were there in the income tax returns, especially the entries of 44AE and 44AD, my lords. And they said that as if these were hiring of vehicles and these were transfer of right to use, and there was an escapement of assessment, my lords, and this 43 was taken up, done, and then it was dropped with a demand of 54,000 some odd. I paid that demand, my lord. After that, my lord, a suo motu proceeding under 79 one was taken up by the additional commissioner. And if you lord, kindly turn to page 57, my lord, as a part of the suo motu order, my lords. The reasons for which it was reopened, my lords. The last two lines of the second paragraph, my lords, page 57, my lords.
Yes.
While passing such order, he refers to that order under 43 of the OVAT Act. The assessing officer found to have not observed anything about why the hiring and leasing amount, which were income of the dealer, will not be a part of the sale turnover. Then he says, my lord, it is an admitted fact that the dealer has filed his return to the income tax department, disclosing his sale turnover out of stone crusher unit and income out of hiring and leasing of goods vehicle, carriage. The learned assessing officer has accepted the sale turnover of the crusher unit products such as stone chips, metal chips, stone bajuri, but not considered the amount received from hiring and leasing of goods carriages. Here it is noteworthy to cite the definition of sale and sale price, whether the amount received on account of hiring and leasing of goods carriage will be the sale price or not. Sale has been defined under Section 245F of the OVAT Act as sale means every transfer of property and goods by one person to another in course of trade or business for cash or for other valuable consideration, and includes a transfer of right to use any goods for any purpose, whether for or not for a specified period, for cash, deferred payment, or other valuable consideration. In the instant case, the dealer has given his machinery and or goods carriage on hire or leasing out and has received payments therefore. So in view of the above, the activities of the dealer will come under sale. Similarly, the sale price has been defined under Section 246C of the Act, which speaks as in relation to transfer of right to use any goods for any purpose, whether or not for a specified period. The consideration or the higher charges received or receivable for such transfer shall be the sale price. In view of these clear-cut definitions, the amount received
what is the demand now?
My lord, the demand now, my lord, they have made it 15 lakhs at page 60, your lordship appraised. 15 lakhs, 12,020, penalty of 28.
Yeah, you pay 50%, sir.
Sorry, my lord?
You pay 50% for stay.
50% were a tax. But here, your lordship would appreciate, my lord. My entire case, my lord, is 44 AE, my lord, your lordship would appreciate.
We'll examine all that, sir.
You just say something less than that. No, then let me pay 20%.
No.
Because my lord, he's in bad shape. Now the quarry is gone.
Yes.
He's no more a holder of any quarry, my lord.
Yes. Nothing seems to have been enforced for more than a year now.
No, your lordship, then appeal, he has filed the appeal.
So you're so kind. So suppose we just issue notice to you, you will not enforce.
No, I have come up.
Mere filing of petition means no enforcement, correct?
No, your lordship.
No, we'll record that statement.
No, your lordship.
You just now said that.
No, your lordship.
Sorry. Once he has filed it, you have said we have stayed off our hands, then we'll ask you to do that only.
I'm sorry, your lordship.
No, you just now said that, sir.
No, lordship.
In fact,
we don't have to then bother ourselves with staying anything.
After the suo motu, I went up in appeal before the commissioner and then a writ petition.
That's right.
Because I was only humbly praying, my lords. The total tax
we just issue notice on both, sir. As it is, they're not enforcing it.
Your lordship,
This issue notice.
Notice
on the writ petition and bus returnable on 24th April. All right.
So, some protection but no cause.
He's not. They're not.
Now they bounce on me. They have.
Their standard policy seems to be many writ petition is filed. Don't do anything.
Notice
so
in IA.
Let us not change.
Sorry.
We have notice in IA also.
Notice in IA.
More than enough. Your purpose will be served. I didn't know this department. Other states, they're not so accommodative. This department is very accommodative.
No, because they appreciate, my lord, they appreciate the fact, my lord, that there's no transfer of right to use. My lord.
Very good. So that's what our work is now listened. You don't have to worry at all. Yes.
There's a miscase for dispensing with filing of certificate.
That miscase is allowed. That dispensing.
Stay maybe
not necessary, sir.
Stay maybe very
accommodative.
Pardon me, lad. Actually, I just wanted to, let's see, just after.
Okay, sir. That's the policy seems to be. Let's not disturb all that. Call it next
Item 22.
Oh, bless you.
22.
May I please? Lordship, here this challenge has been made to the order passed under section 73 of the GST Act. So on the ground of lax jurisdiction as well as on the violation of principle of natural justice. Your Lordship, so far as the lack of jurisdiction is concerned, Your Lordship may kindly have a glance to page 39 annexure 6, running page 39, Your Lordship.
Is it an appealable order, sir?
Appealable order, but that because that provision itself is an unworkable provision, no mechanism is prescribed because they have disallowed my tax credit simply relying on the difference between GST 3B and 2A that is not backed by any law. Whatever the procedures have been adhered under the...
All that you can argue in the appeal, sir.
Your Lordship, Madras High Court has already taken it the issue and admitted this in the absence of any mechanism, the officer cannot travel beyond the jurisdiction because this GST 2A and 3B, the 2A is a facilitation. Your Lordship, that para 20 of the Madras High Court.
So you cite this before the appellate authority?
The problem is the appellate authorities cannot deal with that because there is in absence of any mechanism under the statute. Because they have not yet enabled the GST Act 2 unless until the information flows from the GST Act 2. So no one can be possible.
This you can argue.
Under section 42, yes.
You can argue all this in the
appellate. And your section 107 also provides, Your Lordship, the appellate authority cannot remand the same. Only Your Lordship's intervention can because they have to proceed through manually. Because as Your Lordship already decided in Arranged India case in Delhi High Court, affirmed by Supreme Court. So unless until this selling dealer has been catched up all those things. So they are not alleging selling dealer has not paid.
You're faced with an order now, so you have to challenge that order. You see the order challenge.
No, Your Lordship, section 42.
All right. Passed by the additional CAT and GST officer, CT and GST circle Jatni, is admittedly an appealable one paragraph, consequently permitting the appellate to avail of the appellate remedy, statutory appellate remedy in accordance with law. This court declines to interfere at this stage.
Not delays.
If the appeal is filed not later than 16th January 2023, accompanied by an application for continuation of delay, citing the delay on account of the pendency of the present petition, it could be considered in accordance with law by the appellate authority. The court clarifies it as not expressed in the
Obliged.
Item number 23.
Certificate copy.
May I please, Your Lords? The petitioner before my Lords, the second round litigation of this matter, my Lord. In first round litigation, my Lord, Your Lordship has passed order under Annexure 1, giving direction to dispose of my complaint application later than 7th March 2022, my Lord. My application as per Annexure 9, that is my application in original read petition, where Your Lordship directed to dispose of these things. But in fact, they have not disposed of it and say that we have disposed of it on 15 March 2022, my Lord. But even if 15 March 2022 taken into consideration, it is not the disposal matter, it is only the NFSC circulars matter.
Now there's an assessment, sir. You have to go in appeal now.
Let us say. So far as there are 3 grounds, my Lord. Here in first or second ground is that the order notice 148 has been issued on 1/4/2022-21, my Lord. It has to be issued on 31st of 2021. So that notice itself is bad in law. So this is I am giving that the copy, my Lord.
But all this can be questioned in appeal, sir.
My Lord, when the notice is not 1/4/2021,
right?
So the how the commission how the order will stand, my Lord?
All right. That all you can argue, sir.
It is a question of jurisdiction.
Also, all that can be argued in appeal. Jurisdiction. All that can be argued in appeal.
My Lord, similar matter, Your Lordship has already been decided, my Lord. It is not like this. Similar matter, Your Lordship.
Cite that also before the appellate authorities.
My Lord, similar matter, you have called it was that assessment order, my Lord. So that is this is Jagannath promoter's case, my Lord, giving that order.
All right.
Or 143.3 assessment order has been completed. The reopening of the assessment is within a period of 4 years. Now it is more than years. So how it will stand?
This is a notice of 142021, correct?
142021, they have issued the notice. So it has to be issued prior to 31st March 2021. So it is barred by limitation. So how the assessment order will stand?
Yes.
If you approach the assessment, then they pay 20% of the amount.
Yes.
So I only pray my lord, this may be kindly issue notice. They have filed their counter to this case and decide the matter, your lordships, because your lordship's order is very much there.
Yes.
Jagannath promoter's case. But
Well, it's not in the cusp, so this is not Jagannath promoters has nothing to do with 1/4/2021, 31/3/2021.
Then it is
Different regime now.
So this is after 143.3 order,
Yes.
the limitation of under 147 is 4 years.
Yes.
So it is 6 years, more than 6 years.
Oh.
So then how it will survive, my lord?
All this can be
Even if your lordship's order is very much there,
Yes.
you passed the order by 7th March 2022, my lord.
Right.
They have passed the order 15 March 2022,
Right.
where they have not dealt that aspect at all.
Oh.
It is only a circular of that NFS circular, my lord.
Oh.
So your lordship's order has been violated by that department also.
Oh.
So I pray, my lord, that they will give their counter.
Against the impugned assessment order dated 27 March 2022, the remedy for appeal is available to the petitioner.
Sir, without my fault, I pay 20% of the amount. What is my fault, my lord? In 143.3, they have diluted all my points.
Oh.
Then I go for appeal. Then go for a tribunal.
Correct.
Then 263, their department has initiated. In 263 proceedings, they have raised some points. And in those points, we have already paid tax. After a lapse of 6 years, they have issued notice. And they have passed the order. I have also up to this court. This court has directed to dispose of their representation. Speaking order, that order is not there. Then how your lordship will pass this? We have paid 20% unnecessarily, my lord.
Or
So let that 20% may be protected, my lord.
permitting the petitioner to avail of the statutory remedy. This court declines to interfere at this stage. You filed the original or something?
My lord?
Have you filed any originals?
No, my lord.
You see, if the appeal is filed not later than 1st February 2023, accompanied by an application of condemnation of delay, explaining the delay on account of the pendency of the present petition, it will be considered in accordance with law by the appellate authority. The court clarifies it as expressed in the
And my appeals, right?
Same order the next one.
My lord, similar matter, your lordships are already placed on 1st February 2022, my lord. So far as the date is concerned, 142021 notice of issues they are concerned. The lordship has already admitted the matter and placed the case on 1st week of the February. Similar issue.
All right. But that when we take up that, you tell us we'll pass similar orders. All right.
Lord, my appeals.
All right.
Item number 24.
May please. 24, 25, 26. All these three matters are covered by lordship's order with regard to government land.
All right.
24, my lord, there will be no correction. 25, 26 correction is there. I have corrected.
Right.
Separately, I have given.
All right. Same order.
Item number 27.
The memo is taken on record. No instructions dismissed. Non-prosecution.
Item number 28.
But the petitioner was a manufacturer of salt because his application renewal of license was not acted upon. He came before this honorable court in 2013. Now your lordship have dismissed the case on the ground that the policy has been changed. All along he has been operating. Your lordship may kindly see page 7 of the IA. Now they have issued notice to give vacant possession of the land. We have already started operation. I undertake to complete it by 31st May and thereafter I may be allowed to.
No. This is
because
not...
we have already invested about rupees 3 lakhs and we have 20 workers and they have been paid their regular
you took
wages.
That risk, sir. You took that risk. We can't modify.
I'll pay whatever is due.
Yes.
So let me be allowed to complete the process.
Yes.
Because you have already invested 3 lakhs rupees and engaged 20 persons.
What do you say, Mr. Monty? Who's appearing?
This is union government.
How? Who's there, sir?
Union government.
No, who's appearing?
Mr. Padhi may appear because last time Mr. Padhi was appearing.
No, it's already dismissed, is it? You're not inclined, sir. Mr. Padi, what do you say? He says he's invested 3 lakhs.
And we have
He will give possession by 31st March.
31st May.
Mr. Padi, are we audible to you?
Yes, I am audible, my lord. But Mr. Bhukta is there to assist my lord. I think Cholmo.
Item 28, my lord.
Yes.
Your lordship, kindly have a glance to last order. Lease has not been extended. New rule come into force 2013.
Correct.
Now he has filed a IA. Let us obtain.
We have been
no, they have.
We have been allowed to operate all along.
Not. This lease has already been
long ago.
That is a renewal of lease.
Correct.
So that has not been renewed. And thereafter 2013 rules came into force.
Correct.
But since 2013, I am allowed to operate. All these years.
You didn't take action. You're lucky. That's all.
All these years, so I have already invested. So I may be allowed.
Now you don't get the court's imprimatur, sir. You want now court to give you certificate.
So let him take instruction. He said he submitted that you will take instruction. Let him take instruction.
Your kind cooperation. Sometimes we wonder why are we wasting our time. Everything is getting.
My lord. We can't.
It depends on your benevolence. You say I will also be benevolent. So we are not necessary here. This application all is not necessary, sir.
No,
your kind
request in the meanwhile, we have already we have already issued notice to evict.
Yes, that is what I have placed before your lordship. Because I have already invested. The people will be disengaged.
Sir, a man who does not have license for 10 years, he continues investing and he wants equity in his favor.
They have given. It is not that we forcefully did it. They allowed us to operate.
All right. That's why I'm saying.
So another 6 months only.
We cannot match their benevolence, sir.
No,
as courts, we unnecessarily look for law, legal provisions.
It is not a question of law only, my lord. Besides my investment.
Whereas authorities can be benevolent. Without law and all, they can be
20 regular workers will be disengaged.
Right. Our problem is we look for law.
No, beyond law also, ma'am.
So
compassion.
You're very right, sir.
Kindness.
So very right. So beyond law, don't involve the court.
No, beyond law, I'm not saying that it's violating
any law. Something beyond law, don't come to the court.
Violating any law. I am only seeking compassion.
For matters beyond law, don't come to the court.
I am not against beyond law. I only seek compassion and kindness and taking into consideration his investment, the engagement of 20 workers. And they are not going to lose anything. Let him take instruction.
IAS 16641 of 2022, having examined the application, having heard learned counsel of the parties, the court is not inclined to grant the relief prayed for. The application is dismissed. All right.
Item number 29.
So item 29, there are 11 applications filed by the department, my lords, against the orders by the tribunal. But your lordship have dismissed. Your lordship have dismissed without that delay of 336 days. Your lordship have rejected on the ground that explanation is not satisfactory. Your lordship have rejected IA along with the STRE also. Plus, I have and 8 more matters I have requested lordship
taken on board and do it.
Taken on board and disposed of.
All right.
Out of 11, serial number 8 has already
the order passed on 30th November 2022 in STREV 35 2014. The present petition is also dismissed. In the present application, condition of delay is dismissed, and accordingly, the STREV is dismissed. And then by special notice, you take on board these 11 STREVs.
No, 3 are on board today. 1 has already been dismissed. So 7 are to be taken on board and same order.
7 are taken on board.
I have big bar.
One covered in favor of you. On merit also covered in favor of you.
Anyway, 29, 30, 31 are dismissed, and then the 7 others are from the chart dismissed.
Okay.
Correct.
Item number 32.
My lords.
Yes.
Lords, I will draw your lordship's attention to page 7 of the brief, my lord.
Yes.
This is the order dated 7/11/16 passed by this honorable court.
Yes.
After considering that the present petitioners who belong to a poor family and have only landed property here of 7 decimals in Ranihat, Sagadia Sahi, no other property, my lord. They are only shelter, my lord. And they have been defrauded by this present opposite part number 2 and her husband. That this property has been put to equitable mortgage, my lord. Whereas other properties are there of this present opposite party number 2 and her husband, which can be easily utilized. Part of which can be easily utilized to settle the entire loan amount which they have taken. We have no concern, my lord. Because I needed for daughter's marriage 250,000, and knowing that I need such money, my lord, this opposite party number 2's husband, he said that I will give you 2,05,000, 50,000. I will have to be a guarantor for my loan for a period of 1 year. After which you will repay my amount, and I will release your property from the mortgage and hand it over to you. This was the agreement, my lord. There was an agreement. When this petitioners, they offered 250,000 after 1 year, he refused to give back their property, release it from the bank and give back to the petitioners. Consequently, my lord, ART proceeding was initiated by the bank, wherein this present petitioner's property, small property, was kept as Schedule C, and other properties, properties which have been kept in mortgage, my lord, equitable mortgage, those were numbered as a schedule.
Are you aware you are arguing a review petition?
Yes, my lord.
So what have you to do in a review petition?
Why I am narrating these things, my lords? Because taking these things into consideration, everything into consideration, this order was passed on 7/11/16, which I have quoted at page 7. Lord Counsel for the opposite party number 1 bank.
No, you are seeking review of which order, sir?
No, I am seeking review of the order which was passed just subsequent date. So my grievance is, my lord, this order could not be placed before the honorable bench on that date of the impugned order, because the petitioner himself was appearing. Petitioner is actually a very low literate person. He could not point out that the earlier order is this. So had that been brought to the notice of this court, my lord, this order could not have been passed. Never could have been passed, my lord. The lordship will see. What was the consideration of this court while passing the order dated 7/11/16? I'll just read out some lines, my lord. Lord Counsel for the opposite party bank is directed to file an affidavit indicating what step the bank has taken for recovery of the loan dues against
this order 7/11/16 passed.
My lord.
Petitioner was in person or through lawyer?
No, through lawyer, my lord. It was through lawyer. And this order...
Then he decided to disengage his lawyer.
No, my lord, he could not. His financial condition is such that, my lord, he cannot afford to.
Nice.
Even now also, for I am doing it free of cost.
All right.
The petition is here also.
It's all right, sir. It's all right.
My lord. So this honorable court directed, I'll also kindly permit to read this order, my lord. This is important. This is save this poor family from his losing the property, my lord. Bank has taken, indicating what step the bank has taken for recovery of the loan dues against primary security, that is hypothecation mortgage of the stock in trade, raw materials, stock in process, finished goods, book dates, movable properties of the loanee, as well as hypothecation and plant and machinery of the farm. Said affidavit shall indicate what step has been taken by the bank against Srimati Sushma Mahapatra, Arun Kumar Naik. Arun Kumar Naik is the husband of the opposite party number 2, my lord, and opposite party number 2. And whether these 3 persons have given mortgage to the bank any of their immovable assets. Lord Counsel for opposite party number 2 is directed to file counter affidavit as well as indicate what are the assets in the name of OP2 and her husband. Affidavit should be filed positively within 10 days. On the next day, Learned Counsel for the opposite party number 2 is also directed to ensure the presence of Arun Kumar Naik, husband of OP2. So this is what this Honorable Court directed, my lord. That Arun Kumar Naik did not appear in disobedience, my lord. He did never appear.
These are DRT proceedings,
my lord.
These are proceedings.
Yes, in the DRT proceeding, there is a
so there's a statutory that another route is there, sir. DRAT.
Well, because my lord, because these things are behind the screen, this Honorable Court has taken note of.
No.
Because to save a poor family from the defrauding activity, my lord, of some persons, or husband and wife, my lord.
All right.
They're quite wealthy people, my lord. And pursuant to this order, this opposite number 2 file also an affidavit, my lord.
Right.
That also I have stated.
Right.
Para 13.
Right.
On 13/11/16, OP2 filed her counter affidavit in this writ application, wherein, pursuant to order dated 7/11/16 of the Honorable Court, she disclosed about some immovable properties of Arun Kumar Naik, valued to 90 lakhs, and annexed the copies of the relevant RORs. She also annexed NSRC, her letter dated 23/11/16 to the bank to close her loan account on-time settlement. So this is the situation when she has given that they have properties of more than 90 lakhs, submitted RORs on affidavit, my lord, pursuant to direction of this Honorable Court. She also says that I am ready for one-time settlement. I have given letters to the bank. So this affidavit was also not taken into account on the date when this impugned order was passed. The petitioner could not point out, and the opposite party's lawyers did not point out. I don't know for what reason. Had that been pointed out, had the court turned to the earlier order, my lord, so this order should never have been passed, my lord. I've also got the certified copy of that order, my lord. If lordship will permit, I can pass it.
Not necessary. So how much is owed to the bank, sir?
My lord.
What is the amount due to the bank?
How much we can pay, my lord?
What is due now? Outstanding.
Due, my lord. He had taken a loan of 30 lakhs. My property is hardly it will fetch 9.5 lakhs. And there are other properties which are more than crores. Schedule A, Schedule B. Because I am, we are gullible, my lord. We are available to be duped. That has been done, my lord. Some officers of the bank hands in gloves with this opposite party number 2 and her husband.
Oh.
They have this opposite party number 2 has various industrial units of cashew plantation, cashew processing plants, these things, my lords. Heavily moneyed persons. Our only property has been put at stake.
We'll just get up for 10 minutes.
May please. Lord, I'm only praying before your lordships to come to the rescue of the poor family, or to save its, protect its only property which the poor family has, by taking into account the earlier order passed by this honorable court, the order which I have quoted, my lord, and the affidavit which I filed present opposite part number 2, stating that she is ready to.
So this review petition you filed in 2017.
Yes, my lord.
Which is more than 5 years ago.
My lord.
What has happened in these 5 years, sir?
The same thing, my lord.
No, what is same thing means what?
Now, the loan amount was 51 lakhs with interest, which the petitioners, the opposite party, wanted to settle by making a one-time settlement, one-time payment of 40 lakhs. That was not interfered by the tribunal, my lord, DRT, and she was directed to approach the bank.
So please try and focus on the question that I've asked you.
My lord.
This writ petition was dismissed on 10th March 2017, correct?
Yes, my lord.
And today we are in December 2022. Please answer the question, what has happened in these last 5.5 years, almost 6 years?
Or the factual status, my lord, then lordship may keep it tomorrow.
No, your client right here is in, every time you turn to him and you're able to find out what has happened in the last 5.5 years.
My lord, with regard to what, my lord?
Okay, I have to tell you even that. Nothing has happened to your client in the last 5.5 years.
No, it is pending, my lord.
So nothing has happened.
Sorry,
your property has not been sold.
No.
So what are you worried about then? People are letting you be. Despite you losing in the High Court, nobody has touched you. And you keep saying, poor client, poor client. The man knows how to handle his affairs, sir. He knows how to manage his affairs.
It is pending.
Nothing has happened to him. In fact, you did not even mention this for listing. It has come up on its own course. In its usual course, it has come up. You have never even mentioned it once for listing, sir. It has come up for the first time in 5.5 years.
No.
And you keep saying, poor client, poor client. Nothing has happened. You're better off like this.
But if your lordships will not interfere, my lord,
nothing is happening. We never interfered. You filed this in March 2017. Till today, you have not even got it listed. Without our interfering for the last 6 years, nothing has happened. Yeah, you have got more than, nobody could have been luckier than you.
But if your lordships will not.
No. In fact, we should not. Because you seem to be much better without our interfering, sir. Nothing has happened to your client. Nothing. In fact, if this review petition had not been listed, we have been asking the registry to pull out all the old matters and list it, and that's why it's getting listed. If you had not asked, you would not be for us. He would not be in the court. He will be happily doing whatever he was doing. It's because we listed this matter today, you are getting up and saying all this. Nothing has happened to your client.
The moment
nothing has happened to your client. Nothing will happen also.
They will come to speak, my lord.
We've realized that some of these old matters, it's best to leave it where it is, because nothing happens. Absolutely nothing happens. Because people have learned how to manage outside of all this. They figured out the system. They know how to manage. So all this, what you're trying to project, poor person, this, that, the person has figured out how to do it.
This is the only landlord.
So he has figured out.
1 square inch.
So I'm telling you, even if we today dismiss this petition, nothing will happen. Nothing happened in the last 6 years. We didn't even touch this petition. Nothing happened. Nothing will continue to happen.
First of all, this property will be sold out because
it was not, sir. The last 6 years, the petition got dismissed in March 2017. Did anyone prevent them from selling the property in the last 5 years? Nobody prevented, correct? You did not even challenge it in the court. All you did, quietly file a review petition, let it be. Nobody did anything.
All that I pray, my lord, is that let there be.
In fact, in matters like this, you should not interfere at all, sir. You should not at all interfere.
See, the bank is not worried. How many lakhs? 15 lakhs? How much is stuck up?
30 lakhs loan, now it had come to
50 lakhs. See, the bank is happy. Bank is not worried. Some taxpayers' money only.
And that can be very much cleared.
They'll probably write it off. We don't know what they have, what plans they have, because they don't seem to be interested in selling your property to recover their dues. Look at the reality of the situation. Bank is not worried. Your client is therefore not worried. You are not worried. Because your client is not worried, you are not worried. Only we both are worried. Because the matter is before us. Because it's a pendency of the court. We have to deal with all these old matters. Life goes on. People have arranged their affairs.
Let this property be the last property to be interfered with.
Sir, we should not. In fact, what we will do is, we'll ask you to pay now out of 50 lakhs outstanding. We'll ask you to pay some, let's say 25 lakhs or 30 lakhs for even getting an interim order. You will not be in a position to, correct? Why invite all this? Why invite all
because
this?
Because other properties are there, other original loanees.
Since you are coming for a stay, since you are coming for interim order, we'll ask only you. Because the bank should not be out of pocket. Banks' dues have gone up to 50 lakhs. Correct?
But
so you are not in a position to satisfy all that interim order that we will pass. Correct? Because you have pitched your case so high. You've gone on saying he's a poor person, poor person, poor person. Now even that is not possible. Suppose we give you a conditional stay order. You will not be able to fulfill it.
You will not be able to
so then what is, why waste our time with all this?
That is why I am modulating my prayer.
Nothing has happened in the last 6 years. What are you praying for? You're in a very comfortable position. Let it be.
Maybe, my lord, it is coincidental, but the moment this matter will be disposed of without interference, my lord,
nothing will happen, sir. See, nothing happened. It was never listed. The non-interference happened in March 2017. We dismissed. Our predecessor bench dismissed. That day itself, the negative order from your point of view, adverse order will be passed. For the last 6 years, nothing has happened.
So that does not give me assurance that nothing will happen tomorrow.
We don't know. See how the system has worked. Just see that. Just see how it has worked.
There are other properties, schedule A, B properties, which belong to the loanees himself.
All right.
And with that, my lord, with a part of that property, my lord, the entire loan can be settled.
Thank you.
Whereas if my property is utilized, I will lose the 100% of my property.
All right. No grounds made out for
review. I will
review.
come to street, my lord.
The delay is condoned. No grounds made out for review. The review petition is dismissed. All right.
Item 33.
Item 33, no instruction.
No instructions, yes.
Item number 34.
Item 34 and 35, both states review. One common order was passed on 20th April 2017. And one of such case review was filed in review petition 190 of 2017. On 8th December, your lordships coming to conclusion, no ground for review.
We'll do the same thing as well. All right. No grounds for review. The review petitions are dismissed. Each of these matters. All right.
34 and 35. Item number 36.
Yes.
The question of law is at page 13. Sorry, page 12. A. Whether on the facts and the circumstances of the case, Hiram, pesticide, the fungicide is treated in common parallel as chemical falling within the code of entry 73 of part 1 of schedule appended to the Odisha Entry Tax Act 1999. Whether on the fact and in the circumstances of the case, the London Odisha Tax Tribunal renders convincing finding that serum is not laboratory chemical. Based on the view expressed by professors and head of the Department of Pathology, Odisha University of Agriculture and Technology, Bhubaneswar, ignoring the wider connotation of the word chemicals used for any purpose, as in entry 73 of part 1 of schedule appended to the Odisha Entry Tax Act 1999. May I
What is theorem? What is it?
Theorem is a type of chemical. If it's processed with seed, it will.
Can you speak lesser?
Sorry, sir. It mixed with seeds. The fungicides and pesticides won't eat that seeds.
So it's like a pesticide itself.
Yes, my lord. The entry is.
What is it made of? Theorem. Theorem is a Odia word.
No, my lord.
That
is not theorem.
No, theorem is certainly not an English word. Is it there in the classification list? Theorem is there.
No, my lord. The entry is part 1, serial 73, chemicals used for purpose.
It's 6, is it?
It's 6. Right. Down below, chemical properties with molecular formulas. Ozone is a type of sulfur. It has been
found to dissolve completely in chloroform. Which entry did you say, sir?
Part 1, serial 73.
Entry 70.
My lord. Chemicals used for any purpose.
All right. You just say notice returnable. 25th April.
Item 37.
37 also states revision, my lord. The question of law is that page 12 of the revision petition, my lord. Sorry, my lord. Question of law is at page 14. Whether on the facts and in the circumstances of the case, the learned Orissa Sales Tax Tribunal is not correct to opine that the learned First Appellate Authority cannot travel beyond the materials available in audit visit report, inasmuch as it runs contrary to the provisions contained in section 77(7) of the Odisha Value Added Tax 2004, read with rule 89(3) of the Odisha Value Added Tax rules 2005. The question number Roman 2 is whether on the facts and in the circumstances of the case, the Odisha Sales Tax Tribunal, while relying on the judgment rendered by this,
the tax effect 2734.
No, my lord, the First Appellate Authority has enhanced it. That is the sole question before my lords.
In whose appeal has he enhanced it? In the assessee's appeal?
Yes. By giving him notice, my lord. By opportunity giving to him.
then the provision for enhancement. The extension of assistance. So the tribunal
If he found some wrong reversal of ITC, so he gave him notice.
Audit visit report. But the authority can, is it? So this Bhushan Power and Steel is against you.
That is the assessing authority cannot
go beyond the audit visit report.
But when some documents already there and the assessing authority has not conducted proper verification, what the First Appellate Authority saw, then he gave him notice to show cause.
Enhance.
That's it.
All right. Notice returnable 18th April. All right.
Item 38.
Milord, 38, Milord, I am appearing today, Milord. Milord listed some other day, and I am permitted to file a question of law, Milord. I need some amendment.
He enters appearance for the petitioner and prays for adjournment. List on 10th April.
Item 39.
My lord, states of revision, my lord. The question
9C5.
Yeah, my lord.
All right. One is penalty, the other is the main demand.
Yes.
We have to deal with the second matter first. Both are penalty. One is 9C5, the other is OVAT and
yes.
All right. Notice both notice returnable 18th April. All right.
Item 41.
In this case, opposite patent number 4 to 10, whether belongs to the scheduled caste people, they encroach the public road, and the petitioner also the knowledge of the Tahsildar and the collector, my lord. My representation pending before opposite patent number 1 by annexure 1, my lord. If also direct to dispose, then my prerogative.
What is the proof of delivery of annexure 1?
My lord, when my lord the dependent submitted, then my lord the RI was inquired, and my lord annexure 2 series is the proof, my lord. They have issued. The LE case is initiated, but no action still taken. Though it is a public road, more than 5,000 people are depending upon. Though the enclosure belongs to the civil caste, belongs to civil caste, so they action, and the opposite part number 3 is also absolutely silent.
No. What is proof of delivery of annexure 1, sir?
My lord, by hand, my lord, they deliver, not by registered post, my lord.
No, nothing called delivered. Even you have to have a stamp, sir, even if it's delivered by hand. You make a fresh representation, permitting the petitioner to make a fresh representation to the authorities concerned, and after following up on such representation to seek appropriate remedies in accordance with law, the petition is disposed of.
42.
May I please, my lord. Here, my lord, representation annexure 2, my lord, before the collector Jaspur, my lord, regarding sand quarry, my lord, illegally operating in the vehicle, my lord, in premises of the school premises as well as the ring.
Petitioner's representation, bracket annexure 2, shall be examined by the collector Jaspur. And after notice to the petitioner as well as opposite party number 5, and after giving them a hearing, a reasoned order should be passed not later than 3rd April 2023 and be communicated to the parties within a week thereafter. Court clarifies that it's not expressed anyway.
Item 3.
Item number 43. I pray for 1 week time as some defects are found in.
Defects we removed within a week, list thereafter.
Item 44.
May I please, my lord? My lord, all the petitioners in the present petitions, these are public interest litigations, they are all the senior citizens, my lord, and they are residing at Kapil Prasad at BDA colony, my lord, that's Bhubaneswar, after retirement from different faculty. They are doctors, they are retired RBI officers. And my lord, recently there is a MCC plant, Micro Compose Center.
Why are you not going to the NGT?
My lord, there is no scope for them, my lord. And
NGT, sir.
And besides, they have.
No. Why are you not going to the NGT?
But,
you should go there, sir.
My representations are.
There are no representations here.
Yes, my lord, I have additional documents, my lord.
That's okay. You can go to the NGT, permitting the petitioners to approach the National Green Tribunal. For the
events it will be some difficulty for them, my lord, to.
Permitting, we have said. The petition is disposed. All right.
Item 45.
You respect the grievance raised in the writ petition. The petitioner, before moving this honorable court, has raised the same before the OP number 1 and annexure 12 that is now pending. The registered post is the same has been submitted. On page 35-36, by registered post, the same is submitted. And OP number 1 be directed to look at and take a decision, because my submission before the authorities that in contravention of the rules, statutory rule.
All right. The petitioner's representation dated 22nd November 2022, bracket annexure 12. shall be examined by the Secretary, School and Master Education Department. And after notice to the petitioner and giving him a hearing, a reasoned order shall be passed not later than 3rd April 2023, sorry. And we communicate with the petitioner within a week thereafter. Court clarifies that it is not expressed in the matter.
Item number 46. Item 46.
Pass.
Item number 47.
My lord, the alternate remedy is available.
All right. Counsel, the petitioner seeks leave to withdraw the present petition, liberty to seek other appropriate remedies as may be available to the petitioner in accordance with law. Disposed of as withdrawn, with liberty is paid for.
Appearing from opposite party.
Item 48.
Let's
48.
wait, please, Manas. We need a week's time to remove the defect.
No, it's a 2015 matter.
Lordships, then Manas may kindly pass on Mr. Savi's on his legs.
All right, pass.
Item 49.
49, Lordship will grant me 2 weeks, 2 days time, Lord, to serve extra copies. My lord.
What's the matter about?
This matters relating to my lord's challenge to jurisdiction without any authorization, my lord, under the provisions of the Sales Tax Act. My lord. So Lordship will call it day after, my lord. So in the meantime, I'll serve a copy.
Removed within a week list after. All right.
Item number 50.
May I please, let's have 1 week time for removal.
All right. Because it's be removed within a week list thereafter.
Item 51.
51 is a covered matter relating to the SBDRL 3, my lords. Some I've already served copies on my learned friend, Mr. Satpati, my lords. Due to the pandemic, my lord, it was not possible for the petitioner to discharge the liability as determined under SBDRL DRS 3, my lords. So there's small correction, my lords, in the second line. The amount is then 81,260, my lords.
Period is the same.
Period, my lord, will be from 2008-9 to 13-14.
1081,360.
Sorry, my lords?
1081,360.
I'm sorry.
The amount.
Amount is 1081,260, my lords.
260. And for the period?
Period is 2008-9 to 13-14, my lords. The second period has to be deleted, my lords. And small correction, my lord, at para 2, my lord, after this 31st of December, my lord, your lordship may.
No, 1 minute. There are 2 amounts given
here. My lord, there's only one amount, my lords.
Right. And for the period?
Period is 2008-9 to 13-14. Amount is 10,81,260.
Right.
And the period is 2008-9
so
to
31st January 2023.
What,
31st January 2023.
My lords. And one small addition, my lords.
Yes.
In the meantime, by way of an attachment, they have already realized 4,84,000. So any amount, my lord, realized by way of attachment till date may kindly be considered, my lords. That has to be excluded from this amount of 10 lakhs, my lords. Your lordship may just add a line after this 31st of January 2023, my lords. And I've given the...
you say just add a line, any amount which the petitioner may have already paid.
No, by way of... it was realized by way of attachment.
Yes, may have any amount that may have already been realized by the opposite party by way of attachment shall be taken into account.
While discharging this amount at Form 3, my lords.
While issuing the discharge certificate in Form 3.
Well, payment as per Form 3 and then the discharge certificate.
You may. Okay, will it be taken into account? All right.
Greatly obliged.
All right.
Item 52.
Not press.
Not press dismissed. All right.
Item 53.
Defect be cured within a week list thereafter.
Item number 54.
54 not pressed, your lord.
Dismiss is not pressed. All right.
Item number 55.
Item 55, I am for the opposite party. I have raised the point, maintainability point. You will kindly see the decisions of Honorable Appeal Court.
This matter involves highly technical questions which can be decided by the NGT. And you also kindly see paragraph 40 and 41. There is direction of Honorable Supreme Court to.
Yeah. So you are for the petitioner.
I am for the opposite party pollution control.
Lord, this is a demand with regard to penalty that has been imposed on section 25(2) of 2008 rules.
But you can now go to the NGT.
Sir?
You can now go before the NGT.
I'm sorry.
You can now go before the NGT.
NGT is not required, my lord. There is no question of any pollution here. The substance that is being used, that annex bought, is not hazardous at all. That I can satisfy.
No, that you will satisfy the NGT, sir. This is a demand made under the Environment Protection Act.
No. Is the rule I have given to you.
Hazardous waste.
That is under the Environment Protection Act only, sir.
Yes.
These rules are made only under the EPA.
Sir, here the question is, it is not applicable at all.
That's all right. That you can argue before the NGT, sir. You see, the challenge of the present petition is to be based
boundary hazardous waste
by the State Pollution Control Board on 27th February 2012, imposing a penalty by declaring anode butt as non-hazardous waste. Paragraph. As pointed out by the counsel appearing for the Pollution Control Board by virtue of the judgment of the Supreme Court in Bhopal Gas Peedit Mahila Udyog Sangathan versus Union of India 2012 8 SCC 326.
Paragraph 40 and 41.
This petition, the issue raised in this petition can well be raised before the National Green Tribunal, Calcutta bench. Full stop. If the petitioner approaches the NGT not later than February 2023, then the delay in account of the pendency of the present petition will be taken into account while considering of delay. Full stop. If the petition appeal is filed within the stipulated period, then till such time the NGT takes up the application, passes an order on the application for interim relief. The interim order passed with this court on 3rd April 2012 will continue.
That interim order will continue, my lord.
Till then, the petition is disposed of in the above terms. The court clarifies it as not expressed in the matter.
Item number 56.
It's for restoration, but in the meantime, the petitioner has retired from service.
All right. Counsel, the petitioner says that this petition has been rendered infructuous. It is disposed of. All right.
Item 57.
57, your lordship issued notice. The similar question has already been admitted in ITA number attached.
But notice not served, it says.
Yes, Lord. My seniors are appearing, Mr.
Oh, you're there. All right.
Question number A only.
All right. Admit. Following question is framed for consideration. Both matters.
No, Lord. Second one already question frame.
Question frame. All right. In the first matter.
And listed along with Lord IA number 1 by 2019.
Where is the question set out, sir?
In page 8.
Question A in page 8. All right. So list of final hearing along with ITA 4 of 2019.
And 1 by 2019 also. Same.
And 1 by 2019. 26th April. All right.
58.
The memo is taken on record. No instructions. Dismissed.
Item number 59.
59 Lordship share. Let me see on 19/9/2000. Repeat our appearance. I am appearing for opposite number 5.
Your Lordships, on 19/9/2022, the Lordship directed the state government to clarify the position under Section 4 of the Rule 4 of the Freedom of Religion Act. There was a provision of first-class magistrate, and they themselves admitted that there is no such first-class magistrate either in the CRPC.
What's happened, Mr. Mohanty? Some more time.
Another time.
All right. Mr. Mohanty seeks some more time to file the affidavit in terms of the order dated 19 September 2022. The affidavit positively be filed on or before 6th March 2023. Listen, 20th March.
I don't know, 60. Speak. Item 60.
May I please? My prayer relates to public interest litigation with respect to eviction of the encroachers, because the encroachers opposite part number 5 to 7 encroach the village road. And since the property belongs to Sri Lord Jagannath, so accordingly, the chief administrator of the administration temple administration shall have to act accordingly. On the previous occasion, I have intimated the Learned Council for
Mr. Subrat sir.
As per my instructions, 4 encroachment cases were initiated. That is the encroachment case number 7, 8, 9, 10 of 2019 in respect of the particular plot and khata. That is my instruction. You will also say,
where is it pending?
Before the Tahsildar, that locality.
So you expedite that, sir?
Yes, yes.
Counsel appearing for respondent before informs the court that 4 encroachment cases have been initiated and are pending simply before the Tahsildar Puri.
No, that is not Tahsildar Puri. It is in Bhadrak. It is.
Pardon, I am appearing for opposition 5, 6, and 7, my lord. I am appearing for
Bhadrak.
A direction is issued to the Tahsildar Bhadrak to expeditiously dispose of the said encroachment cases, preferably within a period of 6 months from today.
The petitioner will supply this order to the
copy of this order be produced before the Tahsildar Bhadrak by the petitioner on 9 January 2023. The petition is disposed of near outcomes.
Item 61.
Item 61, I am praying for 1 week time to file a rejoinder.
Rejoinder will be filed before the next date.
Public.
27th.
Item 62.
May it please, my lords. Lordships, in the previous order, my lords are directed Union of India to file its
counter not filed, Mr. Padi. Where is he? Padi is not here. Not in there now.
He has already filed counter.
Two and 3 have filed, not
yes,
1.
1 has not yet.
All right. Well, counter affidavit has been filed by respondents opposite parties 2 and 3. Opposite party number 1 is not yet filed an affidavit. Counter affidavit. Last opposite to do so is granted. The counter affidavit opposite party number 1 be filed positively on or before 1st March 2023. Rejoinder before the next date. 6th April.
Deeply present.
Item number 63.
Yes, sir.
May it please your lordships, this matter has been covered by the judgment of the Supreme Court very recently. It arises out of the Benami Prohibition Act 1988, which was amended in 2016, and in that amendment, the scope of Benami transaction was widened.
Yes.
Now the Supreme Court said that this is not retrospective in operation. I have given the last time the judgment of the Supreme Court, and your lordship also by order dated
1110.
Yes, has also recorded it. Now, my lords,
Mr. Chimanka wanted time.
My lord, against that order, review petition been filed before the Supreme Court.
It will be dismissed very soon.
Yes. Then I
No. You have to go. You have to go by the judgment.
No, we have to wait for review petition now.
My lords. No, my lords.
And moreover, the order is applicable.
What he says may not be correct. Has he got the review petition number?
Then he will take time for that also.
My lords, my difficulties, lordship may kindly give some relief before vacation. As otherwise, my lords,
it's a very pleasant weather, sir. What more relief do you want? All right. You say Mr. Chimanka informs the court that a review petition has been filed against the judgment of the Supreme Court, dated 23rd August 2022, in Civil Appeal number 5780 of 2022. Accordingly, list on 4th April.
4th April, my lords. Then the summer will set in.
Then we can grant you summer vacation.
If it is disposed of,
we'll increase the air conditioning here.
No, if it is disposed of earlier, then liberty may be given.
Yes.
And the
in case the review petition is disposed of, liberty to the parties to mention for listing.
Yes. My lords, the interim order may be absolute. Rule may be made absolute.
I see. Interim order made absolute. All right.
Yes, ma'am.
Item 64.
Connected item is also same.
Order.
Yes. Yes.
Item 64 in both these matters, I've received a counter, my lords. Lordship will grant me some time for a rejoinder.
Rejoinder to be filed before the next date. There's an interim order.
No, there's an interim order in both the cases.
All right. Interim order to continue. List on 12th April.
Obliged, my lords.
Lordship, keep it prior to March because assessment order under challenge, Lord.
Right. Doesn't make a difference. All right.
Obliged, my lords.
65.
65. No, I mean 67.
Item number 65, sir.
My lords.
Yes.
They have not filed any counter. This is annexure 1 is a very...
Lordship, before start, I may pointed some has not yet been admitted. And the second question is not, if your lordship see the order which was challenged, yes, the order which was challenged, 2012. No, 2001 and challenged in 2013 and not yet been admitted. Before start, your lordship, keep in mind, your lordship may hear my senior.
Issue notice. 19/3/2013, my lords. Your lordship.
Yeah. Already notice has been issued.
Issue notice. 3 extra copies be served. Mr. Mahapatra appearing for the Income Tax Department on behalf of the opposite party number 234. An extra copy of the brief also served on Mr. S.D. Das, Council appearing with the Union of India on behalf of requisites of issuance of notice. And I have already served the notices.
Lord, I'll file because I have just not. I've received.
All right, Mr. Satpathy hands over a vakalatnama on behalf of the opposite parties and prays for some time for instructions or to file an affidavit.
I'm sorry, my lord. I am not aware of the.
Or the affidavit, if any, be filed within 4 weeks. Rejoinder before the next date. List on 18th April. After lunch.
That's 66. Sorry. I'm sorry. Extremely sorry.
No, it's okay.
Item 66, my lords, have adjourned till sine day, my lordship, in the similar matters of the petition.
All right. All right. Same order. Both matters.
My lords, all.
4 matters. All right. Put down all the 4 numbers together and.
Item 67.
May it please your lordships. Well, I got puzzled. When I saw Chimaka sitting in my right hand side, whether I am appearing in IT or sales tax. So that is why, well, here, lordship, I'll take just 3 annexes. Annexer 3, 3A at page 26, 29, where the notices issued in Form VAT 307 were issued for the assessment, reassessment. And your lordship will find the period is 1/4/2007 to 31st of March 2008, dated dash. Then minus 3A is that is at page 28. Also for the period 1/4/2008 to 30th of September 2010. When these notices were issued, neither I was self-assessed nor there was any audit assessment. Then, my lords, audit assessment, but before this audit assessment, that is Annexer 2, they have already invoked the power under Section 43. And the audit assessment, the audit team came and visited in 2011. That your lordship will find, that is Annexer 2. Page 16. I'm reading. 20. That is the audit assessment. I am reading page 21. The sales tax officer Raukla 1 Circle Udit Nagar conducted the audit visit instant business on 22nd of August 2011. And thereafter, my lords, in April 2013, the audit assessment was over. And both the assessments, that is this escaped assessment as well as the audit assessment, were going parallelly. That your lordship will find at page 16 of the Annexer 1. Lordship will kindly see page 16. In view of the above allegation, it was considered necessary to reopen the case of assessment under Section 43 of the
Keshav Automobile.
Yes.
That goes.
I have got the judgment. And also another full bench judgment of the High Court, this Honorable Court, where it said that when it is pending, the assessment is pending, you cannot
go for audit.
Reopen.
Oh, the other way around.
Yes, that is my lords in Jayanaran Kedarnath, 68 ST, page 25. That also full bench judgment. That is with regard to the OST Act. Similar position was there in 12.8.
No, so the 43 assessment is bad because of Keshav Automobile.
Yes, ma'am.
And audit assessment is bad because it's not within 6 months, is it?
Yes.
No, that contention is not here, my lord.
Why?
He is challenging only 43 assessment.
All right, he's not challenging the 42 assessment.
No, my lord.
All right.
Okay. Okay, that will be quashed. Don't worry.
My lord, some time to obtain the record, my lord.
For what? This is not even a self-assessment. Self-assessment is also not there.
No.
That is not the pleading of the petitioner.
That's what.
Yes, I have pleaded. I have pleaded. I have enclosed the returns.
You see, notice was issued in the present petition which challenges an order, assessment order dated 20 June 2030, passed under Section 43 of the Orissa Value Added Tax Act 2004 (OAT Act).
the period 1st April 2007 to 31st March 2011 on 2nd July 2014. Full stop. On the same day, interim order was passed staying the said assessment order. Paragraph. Despite the lapse of over 8 years now, no counter affidavit has been filed. Paragraph. In particular, there is no contradiction to deny the averment of the, there is no denial of the averment of the petitioner that prior to the reopening of the proceedings under Section 43 of the Overt Act for the aforementioned period, where have you said you're not self-assessed?
Yes, my lords, I have stated, my lords. Lordship will kindly see para 3.5, 3.6. Then, my lords, para 3.4 also.
Yeah, even before the completion of self-assessment as well as the audit assessment.
Para 4.1.
This averment in para 3.5, 3.7. Has remained uncontroverted.
Yes.
And 4.2 has remained uncontroverted. Paragraph. In view of the legal position explained by this court in Keshav Automobiles with State of Orissa, bracket order dated 1st December 2021, NST-REV 64 of 2016, bracket, which has been upheld in Rati Steels by the Supreme Court of India in its order dated -N Rati Steels. We give the citation. The impugned assessment order cannot obviously be sustained in law and is accordingly hereby set aside. The consequential demands raised are also hereby quashed. The writ petitions allowed in the above terms.
Much obliged. Much obliged.
Item 68.
Item 68. Other similar matters are there, my lord. The state has to obtain those numbers and one day can.
What's the point involved?
So the point actually, this is a reversal of input tax credit. The CST is whether it is less or more than the tax credit. That's the subject matter of dispute primarily. If you lordship, then their own record itself shows CST is much more than the input tax credit. So when the CST is more, the question of reversal doesn't arise. That principle under Section 20, subsection 3D, proviso D, doesn't make any application. That's the simple point that is for adjudication.
If you decide here, then we'll decide in those matters.
Well, let it come, allow it, we will decide on one day.
At the request of counsel for the state, who states that there are some other similar matters, because of which he will provide within 2 days, list these petitions along with those petitions. On 18th April.
The interim order to continue.
Interim orders to continue.
In subitem 3, my lord, my name may be deleted.
All right. The name of Mr.
So I have instructions to appear in this case. Subitem 3, my name may be indicated, not I have instructions to appear.
All right.
Interim order in all cases.
Yeah.
In one of the cases, that other question, that full bench covered case, 7 days.
Audit visit report.
Right.
Item 69. Item number 69.
None appears dismissed.
I am appearing for the department.
Item number 70.
Yeah, and I am in virtual mode, man. These have to become infectious.
All right. Dismissed as infractions. All right. All these matters.
Item 71.
71, Milots. Milots, I beg to appear for the petitioner, Milots. I have been given the NOC yesterday, Milots, on a change of wakalat I'm appearing. Would your lordships give me some time to get ready with this matter?
All right. Mr. Acharya states that he's just
Adjournment has been taken. In a challenge the notice under 148.
Oh.
Lords, sir, just
Stay may kindly vacated.
give me an opportunity. Lords, I'll get ready with this matter.
No, but if it's 148, why do you need all that?
Lords, just
This is all pre-GK and drive shafts and all must be.
Yes, Lords. So, Lords, just give me one opportunity, Lords. I'm appearing on a change of wakalat. I'm standing here with a handicap, Lord. Lordship put any day convenient to your Lordship. Lords.
Oh, he's not even replied to the 148.
A counter.
No, he has not
filed.
We'll give you time. That's enough.
Lords, just a
148. The challenge the present petition. No, the challenge the present petition.
There are two connected applications. That's against the Settlement Commission order, and out of that, this 148 arises is what I have gathered since last.
There's only one connected writ petition.
No, there are two, Lords.
No, only one.
71.
Yeah, in 71 there are two items.
Yes, two items. So, Lords, only
first is a 148. Your Lordship, that you can reply to.
No. 12153 and
8630
and 8630.
Correct. Only two matters.
So yes, Lords, in 12153 it's relating to a Settlement Commission's order.
All right, we'll see that now. As far as this is concerned, 8630,
it arises from that, Lords.
It's all right. Doesn't matter. You just have to reply to this 148. You say the petitioner has come to this court at the stage of receiving of the notice dated 5th March 2015 under section 148 of the Income Tax Act 1961 bracket for the assessment year 2011-12. So the petitioner has not even replied to the said notice. Full stop. It is too early to this court to be interfering. Full stop.
Lots
if in case the petitioner has not already replied to the notice, reply be filed within 4 weeks is the last chance. Full stop. The assessment proceedings will continue in accordance with law. This is the
old law, Lords.
No. Don't say assessment. You say proceedings will continue thereafter in accordance with law. Stop. The petition is disposed of. There's no interim order here, sir.
No.
The other one, Lords, may give me some time, Lords. Get ready. In fact, Lords, last late evening, Lords, I've been handed over the files. So
Mr. Acharya states that he's been handed over the files only late last evening. That is a request list on 24th April.
Malus. Great.
Item 72.
The interim order.
No, it was not continued. Long ago it stopped. Yes.
Very well.
Great. Item 72.
None appears dismissed. 73 also. None appears.
Item 73.
Same.
Item number 74.
My lords, I appear for the petitioners in the second matter in item number 74.
Yes.
Writ petition 5512 of 2014.
All right.
My lords, I need a short accommodation letter. I am actually handicapped today because my father-in-law is admitted in the hospital.
All right. In 2370, you said none appears dismissed. In 551.
I am appearing in appeal number, writ petition number 2370, my lord.
Tell us, what is the matter about?
The matter is exactly similar as the other case. Identical issue involved.
Tell us, you argue then, no problem. We'll decide your petition, the other will get decided automatically.
My lord.
Tell us, what is the matter about?
The matter is that, my lord, in this case, notice has been issued to the opposite parties on the 16th of February 2017. No counter has yet been filed.
No, that's not the point. What's the point involved? You've challenged an assessment order. No, you challenged an adjudication order.
Assessment order is at page 77.
28/10/2016, correct?
Yes, my lord.
That's appealable.
That's an appealable order, my lord. But this order is manifestly contrary to the board's instruction as well as Supreme Court decision.
All right, but that you can urge in appeal, sir.
Instead of relegating me to the appellate forum, my lord, this matter should go back for redecision on the basis of Supreme Court decision.
That the appellate authority will do, sir. That the appellate authority, if it agrees with you, will do that.
But that will be at the cost of paying the pre-deposits, my lord. That will
No, that's all right, sir. Writ petition is not an escape route for that.
But this is manifestly contrary to the decisions of the tribunals as well as High Court.
All right. If challenge the present petition is to an order dated 28th October 2016, passed by the Commissioner, Central Excise Customs and Service Tax, Bhubaneswar 2, Commissionerate, bracket opposite party number 2, full stop. Admittedly, the order is an appealable one. Full stop. Consequently, this court does not propose to interfere at the present stage. Full stop. Permitting the petitioner to avail of the appellate remedy and further clarifying that if such appeal is filed not later than 1st February 2023, accompanied by an application for continuation of delay, citing the pendency of the present petition as the reason for the delay, it will be considered in accordance with law by the appellate authority. The court clarifies it has not expressed any view on merits. Stop. If appeal is accompanied by an application for interim relief, then till such time the appellate authority passes an appropriate order thereon. The interim order passed with this court on 16/2017 will continue. The writ petition is disposed of in the above terms.
My lord, the original order copy.
Yeah, the originals be returned subject to being substituted with attested photocopies thereof.
My lord, in my case, it's slightly different. My lord, I have challenged the stay order by the tribunal, not the original order.
And the stay order was stayed.
No, yes, my lord.
What is the effect of a stay order being stayed?
No, my lord, the appeal proceedings have been stayed before the tribunal because in terms
of we'll ask that appeal to be disposed of and the stay can continue till then.
On merits, my lord, because otherwise on merits.
Correct. The petition has come. Yeah, the petition has come to this court against an interim order dated 9th January 2014 of the SESTAT, declining interim relief to the petitioner. Full stop. While issuing notice in the present petition on 11 July
2014.
This court passed an interim order that there will be stay of further proceedings in the SESTAT till the final disposal of the application. Full stop. That stay order has continued for 8 years now. Paragraph. With the main appeal still pending before the SESTAT, it serves nobody's purpose to keep it pending indefinitely. Full stop. Accordingly, while vacating the interim order passed by this court, the court requests the SESTAT to proceed with the final hearing, with the hearing of the appeal on merits, where all the pleas raised by the present petitioner and any pleas in response thereto will be permitted to be urged in accordance with law. The court clarifies it has not expressed any view on merits. The writ petition is disposed of.
Only praise that no further deposit to be made by me.
There was no interim order on that.
No, it was them. The interim order of the tribunal was this is an order passed prior to the mandatory 7.5% to be deposited. So against a stay application, the Honorable Tribunal had directed me to deposit 25% of the tax demand confirmed, against which I had filed this writ petition. And
so how much are you depositing then?
I'll just point out, in this particular issue, my lords, on merits, subsequent to the order passed in my case, there have been series of orders of the tribunal itself on merits against different assessees, holding that transportation of ore within the mining area is not taxable. And in my case, my lord, same activity, the authorities hold that up to 31st of May 2007 is cargo handling. From 1st June 2007, they say it is mining services. The same activity, they are saying different classifications.
So once pre-deposit provisions have been appealed, there's no question of avoiding pre-deposits.
No, but they're actually, this was the period prior to the statutory requirement of a 7.5% pre-deposit, where tribunal had power.
So how much are you prepared to pay?
My lords, if I may point out, I have complete merits in the entire demand.
That's all right.
I will just point out, my lords. My lords, around this, now after that, the statutory deposit about 7.5%.
You deposit that.
Because otherwise, on merits, I have a complete case. I couldn't come down
All
today
right.
personally.
You see,
to argue the matter.
the appeal will be disposed of within a period of 6 months. Will be endeavored to be disposed of within a period of 6 months, subject, of course, to the petitioner depositing 7.5% of the tax demand within a period of 4 weeks.
Manoj, can Manoj grant me 12 weeks to deposit this? Because I'm in severe financial crisis. That's the reason why the tribunal also, and after the hearing,
8 weeks will say, within 8 weeks. All right. The writ petition is disposed of. A copy of this order be sent to the concerned Sistat bench forthwith. All right.
Completely obliged.
All right.
Obliged.
Item 75.
Please, my lords. The background of the case is that the petitioner participated in the audit proceeding, and after production of the books of account, audit report, provisional audit report passed, and according to that, paid the tax and penalty. Thereafter, my lord, Commissioner of Commercial Tax issued a circular basing on which recasted audit report and notice issued for audit assessment under section 42. That has been challenged before the Honorable Court and that has been quashed. Thereafter, basing on the same recasted audit report, notice as Annexure 1 issued for levy of penalty.
So the main assessment goes, then penalty goes.
No, he has only challenged the show cause notice. So motor revision.
Why have a show cause notice? Assessment itself is gone. Where's the question of show cause notice? Paragraph. You just say the challenge of the present petition is to show cause notice issued to the petitioner under section 79(1) of the OVAT Act, dated 9/11/2017, consequent an assessment order under section 42 of the OVAT Act. So stop. It is the case of the petitioner, which has not been contradicted by the department, despite notice having been issued more than 4 years ago, that the assessment order itself has been quashed. So stop. If that be the position, the question of penalty does not arise. Consequently, the impugn show cause notice is hereby quashed. The writ petition is disposed of.
Item 76.
Manoj, 76, I'm appearing. Manoj, may give me a short date. I don't have the appeal papers with me, Manoj. The petition papers.
At the request of Mr. Agwan, who appears for the petitioner, list on 20th April.
I am appearing on the opposite one.
All right. Obliged, grateful, deeply obliged.
Item 77.
My lord, in this case, countercopy received and 2 weeks time can be allowed for filing rejoinder, my lord.
Rejoinder to be filed before the next date, say 20th April.
Item 78.
78, my lord, similar matters, the lordships have decided.
Same order.
Item 79.
79, my lord, I pay for Passover, my lord.
All right.
Passover.
80 also.
No,
Item
my
80.
lord, 80. I have challenged the
79 may be taken up any other date because that will take
79.
Yes.
Or council petition seeks the Passover which is not convenient to council with the state. List on 19th April.
my lord, interim order to continue.
Interim order to continue.
Item 80.
My lord, here I have challenged the notification issued by the Excise Commissioner, my lord. They have limited the interchangeability of MGQ for the year 15-16 for a certain period. Thereafter, one of the similar writ petition has been disposed of by this honorable court. Thereafter, the government has issued notification allowing a whole period of the year.
So this petitioner is anymore the licensee or not, that is to be. He is no more a licensee. He is no more a licensee.
Then what remains is
These are all
infructuous.
infructuous
My lord,
cases.
they may issue demand.
They may. When they issue, then you will be alert, sir. You will file. The petitioners are no longer licensees, and that way, view of the matter, the petition has been rendered infructuous, it is disposed of as such. Right.
Item 81.
None of this.
Item number 82.
82, my lord, liberty may be granted to file an appeal.
Appeal.
Yes, sir.
Okay. Counsel petitioners leave to withdraw the present petition with liberty to file a statutory appeal as available in accordance with law. If such appeal is filed not later than 1st February 2023, accompanied by an application of condemnation of delay, citing the pendency of the present petition as a reason for the delay, shall be considered in accordance with law by the appeal authority. If it is accompanied by an application for interim relief, then till such time the interim application is disposed of. The interim order passed by this court on 20 July 2017 will continue. Court clarifies it is not expressed in view on merits.
Item number 83.
May I please, your lordship? My lord, your lordship can have a glance over at page 14. Annex 2, petitioner was granted with the on-off license for the excise year 2017-18. His license was valid from 1st April 2016 to 31st March 2017. While continuing as such, all of a sudden, my lord, at Annex 4, page 17, his shop was on account of law and order situations, my lord. Thereafter, I shifted my shop to another site, my lord. That closure period was 22nd April 2016 to 31st March 2017. Now they have come up with a demand, my lord, that Annex 5, which is covered by your lordship. Order. I mean, entire closure period, my lord. They have demanded that Annex 5.
Closure period.
Similar circumstances.
MGQ shall not be, but so far as
License fee. That I paid. My lord's order is there. Near about 11 some odd days, I was not allowed to operate. So thereafter, I shifted to another place and continuing as such, my lord.
Counsel, the petitioner claims that he has shifted his location to another site, and at the old site he was not allowed to operate. And states he has already paid the license fee and is only seeking the relief of waiver of MGQ. Full stop.
Lordship will find Annexus 5 is the demand notice. Annexus 6 also I have paid the statutory fees. The treasury challan I have appended, my lord. That is the duty on part of the petitioner to pay.
You make a representation. That's what we are saying in other matters.
Yes.
For that purpose, the petitioner will be permitted to make a representation to the Excise Commissioner.
Excise Commission.
Not later than 1st February 2023. And if so made, such application will be considered on merits in the course of a period of 3 months. Till such time, no coercive steps will be taken against the petitioner for recovery of such MGQ.
Demanded amount.
The petition is disposed of.
Item number 84.
Well, I will have to file appeal, my lord.
No. Representation.
Item 80.
Obliged, my
lord. 84.
None of this is disposed.
Item number 85.
All the matters relating to interchangeability of the excise year 2017-18. By efflux of time, all matters are becoming infructuous.
All right.
If any cause of action survives, my lord.
Nothing.
Because they may
by efflux of time, all these petitions have been rendered infructuous and are disposed of as such. Fresh cause of action, Mr. Biraj Prasanna Das will immediately have petitions ready.
Maximum petitions, they are no more licensing. They are no more license.
This is good for you. Because again, you
obliged.
Mr. Das, people like you who have bulk filing. Why don't you do e-filing?
Yes, my lord.
It will help. It will encourage the youngsters also to do it.
So I am trying to renovate my chambers.
Then all your huge volume of papers, you can make a paperless office.
Paperless.
I was also asking all Mr. Ratho and Mr. Patro.
And Mr. Sahu. You should now do only e-filing.
It will be effective.
I'll pass a judicial order saying Mr. Jagavantu Sahu will only do e-filing.
do that, but that is at times little difficult.
Whatever it is, you pointed to us. We'll iron out those difficulties.
He has good
We'll do that. During
Ah,
COVID days, we are
your
doing-
daughter is must be an expert in it now.
During COVID days, in fact, we are doing 100% e-filing we are doing.
Just do continue it. See, if some of you'll take the lead, then the others will follow. We don't want to compel anyone, but bulk filing, I mean, those chambers must adopt.
We will
Yeah.
do that. That
All
will save paper also.
Correct. All right.
Okay, pass. Wiki list passed on item number 6.
This is the appeal against the order dated 8/8/2017, passing double petition number 9197 of 2013. By virtue of the advertisement under Annexure 2, running page 19, the appellant, this is advertisement by the district project officer, Sarva Shiksha Abhijan, Baleshwar. So the appellant having.
So you got your postgraduate degree from an unrecognized university.
Not postgraduate degree, it is under the recognized university.
Degree from unrecognized.
Degree from one.
So either way, sir, you have to go to recognized.
So in the advertisement, the degree or postgraduate degree.
Both have to be from recognized university. That is obvious. That is an implicit understanding of such clauses. There's no escape from that.
You'll also may have the Annexure 2, my lord.
Yes.
Page
paper cutting.
Page item 2, that is the art education instructor. That is degree in visual art, fine art, or postgraduate taken in visual art, fine art. Or so the appellant is having the postgraduate degree from the recognized university, but she has not been. But the appellant has not been considered for the selection.
That's obvious, sir. The degree is not from recognized university.
But however, she has obtained that postgraduate degree. That is the recognized from the recognized university. Okay, the candidate should make the draft selection list was prepared and her name was appeared. And under Annexure 3, by notification after the verification of the documents,
you got your post graduation from which university?
Indira, that is from the university, the Indira Kala Sangeet Vishwavidyalaya, Khairabad, MP, which is now in Chhattisgarh. So which is recognized by the UGC.
When? Now?
That is under Annexure 9, my lord. That is page.
No, from which date?
My lord?
From which date was it recognized?
That is in the recognized list. That is your lordship.
When was it published? This recognition. What is the date of this?
A date is not been mentioned here, but the list of
No, that is crucial. That is crucial.
List of institutions are there, but date has not been mentioned here. No,
This annexure must have some covering letter. This only list.
Other incumbent.
No, that's all right. The challenge in the present appeal is to an order dated 8th August 2017 passed by the Honorable Single Judge dismissing writ petition civil 9197 of 2013 filed with the present appellate, whose name did not find place in the final merit list of candidates who applied for the post of part-time art education instructor bracket performing art at the not at the full stop performing art Baleshwar full stop. A perusal of the advertisement reveals that the requisite qualification was open quotation degree in visual arts / fine art or postgraduate in visual art / fine art. The learned single judge found that the appellant had obtained the graduation from Akhil Bharatiya Gandharva Mahavidyalaya, Mumbai, which was at the relevant time not a university within the meaning of section 2 bracket F of the UGC Act 1956. The said institution did not come within the purview of UGC paragraph. As a result, although the petitioner appellant had a postgraduate degree from a recognized university, graduate degree was not full stop. On this short ground that she did not satisfy the requisite qualification, her candidature was rejected. Paragraph. Counsel for the appellant contends that since the minimum qualification was either graduation or post-graduation, command as long as the postgraduate degree was from a recognized institution, the petitioner should not be deprived of an appointment. Full stop. It is an implicit condition of all such advertisements for teaching posts that the degrees, whether graduate or postgraduate, should be from recognized institutions. Paragraph. In the circumstances, the court is unable to find any error having been committed by the single judge. The writ appeal is dismissed.
Pastor matter item 46. Item number 46.
None appeal is dismissed.
Item number 48.
None appeal is despite a password.
So item 48 minutes, there are some defects minutes, your lordship may permit to remove, and after removal, this may kindly be deleted.
2015 matter, sir.
Sorry, my lords.
It's 2015 matter.
2015 matter, my lords. A provision is under challenge. And this is a substantive issue involved in this case. And these are trivial defects, I will remove, my lords.
What's the issue?
Issue, my lords, yes. So, the issue is concerned, my lords. The input tax credit, my lords. I have challenged, my lords, Rule 11. My lords may kindly say Rule 11(3) A, B, C, D, and E, which has come up by way of Orissa Amendment, Value Added Tax Amendment Rules 2005. Right. And this amending rules, is directly the ultra-affairs.
Come to the prayer clause. There's no mention of the rules in the prayer clause.
My lords may kindly see the prayer, my lords. Calling upon the opposite party to show us why Proviso D2 subsection 3 of section 20 of the Orissa Valuable Tax Amendment Act by Law Department notification number so and so shall not be declared alter affairs and article so and so of the Constitution, and further why order of assessment dated so and so shall not be quashed being illegal.
No mention of any rules.
11B.
There's no mention of any rules.
Rule will not be declared. Notification number. Notification this 248 by 2008. Dated 28/5/2008. So that is annexure Millers, page 40, page 40 Millers. The finance notice. There are two notifications. One is by Law Department, other Finance Department. Finance Department is by amending the rules, and Law Department the Act Millers. And this page 40, my lords may kindly see. Sorry, page 41. 40 is only the appointed date. Page 41 Millers, the 2009 rules, and here it says, kindly see the next page. That is, yes, that is page 42. In the said rules in Rule 11, Sub-Rule 2 shall be substituted by following the Sub-Rule namely. Now this is added per Rule 2, subject to condition prescribed Rule subsection 5 of section 20, A, B, so C, D, all this. But the essence of the amending provision is that your lordship will be appreciating things. Because whatever output tax I do have, Millers, and towards central sales tax liability, CST liability, Millers, my liability, output tax liability, vis-a-vis the available input tax credit, Millers, that will be confined to my liability. If there is any excess, that will be extinguished, Millers. Extinguished. Millers, if your lordship will see central sales tax, this is under the domain of Article 269, Millers, 286.
Notice has not gone in this.
Notice has not gone. My friend was also.
All right. Notice returnable. 18th April.
My lord, similar. Yes, my lord. Similar matter has been posted to 8th of April.
8th of April.
Yes, my lord.
Notice returnable 8th. Right.
Let's, your lordship, kindly pardon me. This is item number, Millers, 62. Wrongly, my associate sought for adjournment, which I have no instruction to do that. But I have requested my friend, Mr. Satpathy, is there. Because this is have wider ramification, Millers. Hundreds of cases will come, Millers. Your lordship, kindly will not take it up. I will take a little time.
All right. Item 62, you say at the request of Mr. Sahul and Senior Counsel. 12th April.
Yes, sir. What I am praying may kindly taken up, Millers, so that
It's been adjourned to 6th April, he says.
6th April. No, I said that I'm seeking adjournment was a mistake, Millers. I'm sorry. I was not, in fact, in favor of praying for adjournment. I requested my friend to come, Millers. So that only I am praying, your lordship.
No, let me be.
No, my lord, Government of India has not filed any counter in this case.
Not counter. What has happened, Millers? Let's say your lordship have said, now that a notification has come extending the date of filing of return, so paragraph part 4 of the prayer stands complied with. Now, what is happening, Millers? Millers, date of extension is allowed, but consequential, penalty and interest, Millers. Millers, now for that, that is a judgment of Honorable Gujarat High Court by Honorable Justice Millers Padiwala. And that judgment says, so far as 271D penalty is concerned, Millers, consequential things, Millers. Honorable Court has dealt with the notification. The CBDT was pleased to extend the date. That part is all right. But CBDT in exchange of power 119 has not taken their consequential action. Something else, one extends the date. And the extension of date is not my fault because of the portal fault. And not only that, the software has already, Government of India.
It needs to be complete.
Sorry?
Union of India has to file a reply, sir. You're challenging the validity of a statute. Union of India has to file a reply.
Union of India have to file a reply. But so what I am saying, I have filed an IA. In respect of IA, I want some protection or notice may go. Only
Notice.
Notice may go.
IA 4378 of 2022, notice returnable the same date. 8th April, right? 6th April. Right.
Copy. Deeply obliged.
All right.
How would it
How far have we come in the weekly list?
Beg your pardon, my lord. Item 48 has been posted to 18th of April 2023.
Okay. 48, 18. Okay.
Thank you.
All right. Weekly.
Weekly list for hearing, item number 1.
My lord needs some time to constitute the brief. It is misplaced.
No. 2001 matters, 20 years now, 21 years. We are not at June. Yeah. Correct. Right. In the last 21 years of the pendency of the present revision petitions, not even a question of law has been framed. The court does not see any purpose being served to entertain the revision petitions at this stage, at this later stage, leaving the questions of law, if any, open for decision in some other appropriate case. The petitions are disposed of. Both matters.
For hearing, item number 2.
One Passover, Mr. Chimanka is election other court. Passover.
Which one?
Item number 2.
You're for the petitioner. I mean, appellant.
Appellant.
Passover for what?
Mr. Chimanka is another.
Still on board.
Item number 3.
3 also, my lord, Passover.
Okay.
So small Passover. My lord, Mr. Misra has. Other matters, sir.
Okay. Yes, sir. Item 3. Item 2. Yes, sir.
My Passover, my lord, I have not gone through this requirement.
Anyone ready in any of the matters?
I am ready, my lord. In item 12 and 13. Item 12 is very important, my lords. It involves questions of law of national.
Lordship, I'm appearing in item 9. I'm ready. I'm for the respondent, but it's against state's revision. 21.
4 also, my lords, we are ready. Subject to your lordship's kind convenience, if your lordships are.
Yeah, just see.
Item number 26, I am ready also.
Well, item 5, I am ready for respondent, my lord.
Yeah.
My lord, item 11, 14, moreover, a covered matter, my lord. Apart from item 19, 22, my lords. Item 19 and 22, my lords.
Covered in your favor?
No, item 11 and item 14 is against me, my lord. It's covered, my lord. And apart from the item 19 and item 22, my lord.
Yeah, so we'll do one by one. So
My lord.
14 and 11 and 14.
11 and 14, my lord.
Covered against you by?
By SB matter, my lord.
11:14, you say the petitioner informs the court that the issue has been decided against the C in favor of the department by the decision dated.
Apart from the advantage, there is only a short question to be decided, my lords, which has also been covered by the Commissioner Circular, your lordships. For the short payment, for the demand for non-SIMS declaration form, penalty shall not be leviable. As per the circular of the Commission dated 20th of April 2015, my lord.
In view of the order dated 8th December 2022, passed by this court in STREV 59 of 2016, Messrs. SB Enterprises Bhubaneswar, State of Orissa. The questions raised in the present two revision petitions. This is 36 and 44, correct?
My lord.
36 and 44 of 2017.
STVR 36 for 2017, my lord.
And the other matter is 44.
My lord.
Both same orders, correct?
But slightly different, your lordships. In case of 36, apart from the administrative tax liability also, there is a demand for non-submission declaration form for which penalty is not leviable, covered by the Commissioner Circulars, my lord. I have placed already the copy of the circulars, your lordships.
Upload. Correct. Both the issues are decided in favor of the assessing against the department.
I just want a small issue, lordship. Although the third issue is not with relating to financial condition is concerned, my lords, where I have filed the returns, declared in the returns due to non-action of the revenue for scrutiny of the return, I shall not be held as a fraudulent dealer, your lordship. That is a words have been used against me in the internal, my lords.
No, but you allowing both the questions in your favor, which have been raised.
With regard to non-submission of declaration forms,
yes,
on 8th we have taken a decision.
My lord.
In another case, taking into account this Commissioner Circular
My lord.
in favor of assessee. In respect of non-submission of declaration forms.
Yes, ma'am. Oblige, ma'am.
So 12(3)G is not applicable.
My lord.
Then any other point you want to agitate in this case?
My lord, so I shall not be held as a fraudulent dealer, my lord.
That is another aspect. That is another aspect.
Yes, my lord.
Right. So no, do we issue notice here? What do you do? 11 and 14. 11 and 14, right?
Yes,
item numbers 11 and 14.
My lord.
No, do we follow this SB Enterprises or we don't follow?
My lord, there is a clear findings of the Honorable Tribunal, your lordship. There is short payment of 1,59,000, your lordships.
Okay.
And the short payment has been already been the return, my lords, your lordships. It is an admitted liability of the petitioner, your lordships. Para 6, your lordships.
So to that extent, it is against you.
SP is against me, but that is the order of the my lords. I have put forth before my lords. SB Enterprises is against me, but I just put forth this is the order I have asked my lords. I just put forth.
First two questions which you are agitating, that is with regard to non-submission of declaration forms, that is in your favor.
My lord.
The other part that covers this decision against you.
My lord.
That is what it is. So he is not aware of
that. Correct.
My lord, 8th have decided, my lord, where I will argue in the matter whether the tax due and tax assess, and my lord, once it is assessed among the tax assessed.
Agree with.
I just brought to knowledge of my lord. This order passed to that.
Correct. So where is the conflict of that judgment? To this. Yesterday.
ଏଇଟା କଣ CST ର
May not have uploaded.
ସେ ସର୍କୁଲାର ଟା ଅଛି ଦେଲେ ସେଇଠି ବାଡେଇ
So let us do one thing. It will retain its position. You see the judgment. We've just delivered it yesterday.
On 8th, my lord.
8. So you examine it and then we'll take it up tomorrow day after. Yeah.
Mr.
Whereas-
Sou's case, Mr. Jagabandhu Sou's case.
My
Mr.
lords,
Jagabandhu Sou's case.
ଜଗବନ୍ଧୁ ସାହୁ କେସ୍ ଜଗବନ୍ଧୁ ବାହାରୁ ଗଲେଣି
In
My
this
lords,
case, we have delivered a judgment on 8th.
I will give the number.
Today you will be finding in your website.
My lords, item 13 similarly that penal interest under rule 8A1 for non-filing of the declaration form.
This is different, my lord. This is regarding penalty. This is regarding interest.
Right.
Interest
Interest,
8A1.
my lord.
ଏକା କଥା ନୁହଁ
କେମିତି ଏକା କଥା ହେଲା?
So what is the item number earlier which we passed?
Sir, my lord, it is item 13 STRB 39 of 2017.
Similar to which item?
No, my lord, this is not similar to that item. That is regarding 12(3)(z) penalty. But here interest under section 9(2) of the CST Act.
9(2) ନୁହଁ
Again.
9(2) ନୁହଁ that is the 1% interest you have charged under rule 8(1). Then again penal interest at the rate of 2%.
Interest of
Penal interest. I am only I'll confine my to penal interest.
Then my lord.
Yes, 81,660 penal interest without opportunity of hearing. It is, my lords, unbelievable. And the statute is that you have to give an opportunity of hearing because while imposing the penalty. Penal interest. କାହିଁକି ମୁଁ ଯିବି ମ ତମେ ତ opportunity.
Mr. Sau, that is STRB 64 of 2017.
No, STRB 4 of 2017 SK Dal case.
No. Subsequent.
Last week
64 of 2017.
64 of 2017.
General
yes.
General traders.
Yes. I
General
have forgotten the name.
Yes. And the notification is 2015 notification. Circular.
That we have taken cognizance.
Item number 21 is the covered issue.
No, I say about 13 ta. STRB 39 of 2017. Here, my lords, the period is 7 to April 2007 to March 2012. Demand of rupees 6,03,700.
Only one question framed on 14 July 2017.
Beg your pardon, my lords.
One question has been framed on 14th July 2017.
My lords. Yes.
That only penal interest.
Penal interest.
No, not the other interest.
No.
Two types of interest are there.
Yes.
Under
I am much obliged.
8A1.
So in view of which decision now? General traders. Where is that?
Beg your pardon, my lords.
That decision you have, general traders, 64 of 2017.
STRB 64 of 2007. Upload question.
No. We just get a copy. Or we'll take it up tomorrow. We'll get a copy of the judgment, sir. It must be uploaded.
My lords, tomorrow, actually, my lords, I will not be there. I'm going for Hyderabad. And therefore, my lords.
We'll call it whenever you're the judgment copy.
Item 26 maybe is after vacation.
No, we'll all stay on board only, sir. This is weekly list.
Weekly list.
Weekly
list.
I may be pardon your lordships. Item 17 actually less tax effect, your lordships. Only 30,000. Item 17.
Given the fact that the tax effect is minimal, the court is not inclined to interfere.
32 and 33.
The petition is disposed of, leaving the questions of law open for decisions of other cases.
Item 32 and 33. Department has not filed counter. It is already admitted by the honorable court. If they file counter, then it will take any date find out. Later the government has to file counter.
IPA, why should counter and all be filed?
21 is a covered issue. 21 is a covered issue of giving the judgment, my lord. 21, Kaju notes. The question of law framed by the Honorable Court on 10 May 2018, my lord, whether on the facts and in circumstances of the case, Lorna Celtex Tribunal is justified in set aside the order of the Joint Commissioner of Commercial Tax in Annex 2, thereby restoring the order of assessing of
This is of Sadashiva Rao.
Sadashiva Rao. It is Odisha High Court decision, or it is clearly decided. Kaju nuts are not a fruit.
Now there the question is, cashew nut is fruit or not. But here dry fruit, dry fruit is there in the entry. Entry is slightly different. In the Entry Tax Act, the entry is dry fruit, whether cashew.
Dry fruits in package form, that is entry number 20, but it is only cashew. So it is not a fruit. They have made tax taking it as fruits.
No. What I am saying, the decision which you are relying on, there the question was whether cashew nut was comprehended in the term fruit. But here the entry in entry tax is dry fruit. Whether cashew nut is a dry fruit or not.
It is.
That is the question there. Here in your case. So can this case which you are relying on be covered?
The tribunal is also taking this case in single bench as allowed the appeal.
But I think department has come up and that is admitted. Admitted.
Yes, ma'am.
Recently we have admitted that.
Salted cashew has been decided. Salted cashew has been decided by my lord. But cashew, whether within the
that is admitted.
Yes, sir. That is admitted. State's case.
No. You tell us that name.
You have to get us an order and get us a copy of the order. Let it stay on board then. This will also stay on board.
Item number 7, my lord. Item 7, my lord, on behalf of Mr. Mahapatra, my lord, taken up next week, my lord.
It's all stay on boards.
My lord, suffering from throat infection, so.
My lord, item 35, my lord, is covered matter.
My lord, item number 26 income tax matter. Item number 26.
What does it tell us?
Let us come after vacation.
Lord, stay on board, sir. Now it's only 1 week.
Your lordship, item number 35 is covered matter, my lord. 35 is covered matter.
Covered in whose favor?
My lord, assessment has been completed. Assessment for the period of 5-6 has to be completed 31st March 2009. It has been completed on 21st February 2009. But whereas it has been issued on 11th August 2009, it has already been covered, my lord. Your Honor.
Who's for the department?
6 months delay in issuing the 6 months delay in issuing the assessment order.
Same order can be passed?
I was appearing in this case. Before the tribunal. I submitted certain documents there.
Oh, okay. This before a bench of which Justice someone is not a member. In the miscellaneous board.
Your lordship, item 9, your lordship will be taking it up tomorrow. Your lordship, because I'm traveling from outside Delhi. Odisha. So
whenever it's called out, these are only weekly list matters. All right.
It's item 9, your lordship, weekly list only.